8/21 of 2024.
Petition allowed.
My lordship, on 22, I have mentioned the matter and your lordship permitted for today, but not listed. We have some urgency in the matter. My land may be taken. It may kindly be taken today as unlisted at 2 p.m.
Tomorrow.
tomorrow.
Huh? Okay. Okay, we'll try as last item today.
Today.
Please, your lordship. My lord, in today's list, I have two RSA listed for hearing, 14 and 15, my lord.
Hmm.
So, my lord, in one of the matter, item number 14, I may be allowed some accommodation, my lord. 15, I will argue, my lord.
When?
14, my lord, on the second week, my lord. Second week of August.
Check for me. Yes.
I beg to mention item number
On
16.
28 August.
Item number
I'm-
16.
Yes, I am on behalf of Analog for the respondent.
Item number 16.
16. 16.
Mr. Your good name?
SJ Rajbangsi.
Learned
A date
counsel
may be
appearing on
fixed,
behalf of Mr. N. Along, learned conducting counsel for the respondent with consent from the other side as per listing the matter after
Second week of August. A
second.
date may be fixed, Lordship.
Second, in the month of September.
September,
On 4th September.
4th September. Obliged, Lordship.
Yes.
Lordship, back to mention, Lordship, on I have for Lordship listing on Monday, Lordship. I is for withdrawal, Lordship, of that appeal.
Yeah, please, Lord. Lordship, I beg to mention item number 10, Lordship. With the consent of other side is present, Lordship. In this matter, Lordship, one advocate is conducted from Delhi, Lordship. Due to some injury, he could not appear today, Lordship. It will come up after 2 weeks.
After 2 weeks.
Yes, 18 or 22 suggested date, Lord. 18.
You are for the respondent?
Lordship, I'm for the respondent, my lord.
Okay. As agreed by learned advocates of both the parties, raises at least the matter in the second
22
week of
August, 22.
22. Yes?
Lordship, 22, 2nd August, lord.
Okay. No. 22nd.
22nd August, my lord.
Interim order is there. Interim may be continued.
Okay, interim order pass earlier, shall continue.
Oh.
Yes.
I beg to mention for listing of a matrimonial appeal in the
When?
hearing, Lordship.
When?
Next week, Thursday, next Thursday, this is the hearing column. It will be
Hearing column.
Hearing column.
Not possible. In the month of August.
2020 meter, my lord,
On 26th August.
26. Public.
Thank you, Your Lordship. Lordship, I beg to mention for listing one MFA in hearing column. Lordship, it's a whole pending matter in the year of 2013. Lordship, matter may be fixed on 19th of August.
19th.
Okay. Yes.
Please, your lordship. Lordship, I would beg to mention item number 13,
1-3.
1-3. Lordship, my senior Mr. A. Sattar is unwell today. Kindly grant some accommodation.
You inform the other side?
No,
You inform the other side?
no, lordship, not yet.
You obtain consent from the other side?
No, lordship, not yet.
Then we will call the matter.
Okay, lordship. Obliged.
Wait, please, your lordship. Okay, I beg to mention item number 22, lordship.
22.
With the consent of other persons. Consent, lordship.
When do we want?
I am for the petitioner, lordship.
Lordship, first week of the August.
First week of August.
Lordship, there is an interim order. Continue.
Lordship, last week of August. Last week of August.
Last week of August.
Last.
Suggested.
On 26th August.
As agreed by learned advocates of both the parties, registers and list the matter on
26th August.
26 August. Till an interim order pass earlier shall continue.
Much obliged.
My pleasure. I beg to mention item number 21, madam. I have taken consent from other side.
Mr.
AK Azad.
A.K. Azad.
Azad.
Learned counsel for the appellant. With consent from the other side, pays for listing the matter. When?
In the month of
In the month of September.
September.
On
The second week of
second week of August. No, not second. Not in the month of August. So many cases. On 9th September. 9th September.
I got a call.
2nd September.
Second. of
2nd
September.
September.
Highly obliged.
Most obliged.
May I please, Your Lordship? Your Lordship, I beg to mention one RSA for listing in orders column, Lordship. Can it be on Monday, Lordship?
Okay.
Obvious.
For withdrawal. Item number 1.
Mr.
T Mojumdar on behalf of PC Mojumdar.
D. Mozumdar.
Yes.
Mr. D. Mozumdar, learned counsel appearing on behalf of Mr.
PC Mojumdar.
Mr. P.C. Mozumdar, learned conducting counsel for the petitioner, submits that he has the instruction to withdraw this petition. There is accordingly allowed. This CRP IO number so stands dispose of on withdrawal.
Items for mediation. Item number 2.
May I please, Lordship? Lordship, since it is part heard matter, my lord, let the matter may be fixed for hearing, my lord. It is part heard matter, my lord.
Maybe there is no chance for reconciliation.
My lord, since the insurance company is not liable, my lord. They have no valid insurance
Okay.
policy, my lord. Owner is liable for it, my lord.
Heard Miss
L. Sharma.
L. Sharma, learned counsel for the appellant, and Miss
SR Das on behalf of AT Sarkar.
S.R. Das, learned counsel appearing on behalf of Mr. A.T.
It's-
Sarkar, learned counsel for the respondent. It is submitted at the bar that though the case has been referred under the column for referral to the special mediation drive, that's mediation, then inverted comma for the nation. Yet the matter is part heard before this court,
No, my lord, before this court, my lord.
and there is no chance for settlement, amicable settlement, and as such, it is contended to list the matter for final hearing. Here is accordingly allowed. Rest is list the matter on
9 September.
Obliged, my lord.
Obliged.
Item 3.
No, sir, this is a matter that relates to issuance of policy, so this has to go for hearing, not.
hearing.
Last occasion it was fixed for hearing, my lord.
Okay, same order. On when?
Short date may be given. It is long pending case, my lord.
September. 2nd September.
Obliged.
Item 4.
Obliged.
Wait, your lordship, my lord, this matter cannot be settled, lordship.
Cannot be settled.
Yes, lordship,
So date must be fixed.
as lordship, my lord, as per Matthewson record, our vehicle is not at all, there is no negligence on our part, lordship. Therefore, it is already fixed for hearing, lordship. Matter may be. fixed
Mr. Bhatta says that perhaps we have heard this matter partly. Earlier?
No, lordship. No, lordship,
No,
lordship.
fine. First hearing.
So on the other day, you have submitted on calculation sheet.
This is not.
No,
This is not the case.
that is not the case, no.
Okay.
That is Kitab Jan BB, that is separate.
Okay.
That has to be listed, my lord.
Heard Ms.
M.
M.
Ped.
Chaudhary, learned counsel for the appellant, and Mr. Bhattacharya, learned counsel for the respondent. Same order?
Maybe.
When?
Fixed for hearing.
When?
Any date, my.
In the month of August, lordship. Last week,
August may not be possible.
September.
September, second, my lord, 2nd September.
4th September.
4th September.
Yes.
Obliged.
Must oblige, lordship.
Item 5.
Wait, please, your lordship. If my lord permits, my lord, the core issue is not about the under mediation level. Direction was given, the Wagoner and a truck collided, my lord, frontal, and the persons died in the Wagoner, as against which the claim petition was filed. Now, it was allowed, but the direction was to the insurer of the Wagoner and not of the truck. In those circumstances, we were praying for a remand of the matter. That's, I mean,
Who is for the other side?
other side, Mr. R.C. Paul appears.
Who?
Mr. Paul appears, R.C. Paul, correspondent number 2.
Is he present in the court today?
I do not see, I had a word with him earlier, not today. And the other insurance party services complete, they have not represented. I was expecting the matter to be listed for orders, my lord. We had made a mention earlier. This was listed under the mediation column though. Only on that count, nothing more. Can be taken up tomorrow, my lord. This matter tomorrow. I'll inform Mr. Paul. Because only on the direct, because there was a charge sheet given by the police authorities in implicating the truck, and the insurance level said, no, it's not frontal, it's back, it's back. The car hit the truck. So these evidences were not considered and direction to the wagoner. That's only thing,
Tomorrow, okay, possible?
only for remand, my lord.
Can we fix it on Monday?
Monday, my lord.
Monday?
Absolutely, Monday. For orders.
Heard Mr.
Yes, but
Ronick, learned counsel for the appellant, none appears for the respondent on call, list the matter on Monday.
for orders.
6.
Lordship, my senior is just coming. Kindly pass over for the time being.
Okay.
Item 7.
Your lordship must send it for mediation. For mediation, lordship.
Can be. Heard Ms. S. Roy, learned counsel for the appellant, and Madam Souduri for the respondent.
Number 3, lordship.
This appeal is listed today under the column for referral to the special mediation drive, mediation coordination. It is submitted at the bar that there is chance of amicable settlement between the parties, and as such, the matter may be referred to the mediation. Accordingly, the matter is then referred to the High Court Mediation Center. The parties are directed to appear before the mediator on when?
August 1st.
Yes. 8 August.
8 August, please.
8th of August. 8th of August.
Must have been.
Therefore, the mediator shall furnish a report before this court. On or before.
On 1st September.
1st of September.
Item 8.
No, sir, this matter can go for mediation. It's on quantum.
Yep.
Item 9.
Lord, it may be go for mediation. It is only for future prospecting thing. No other dispute.
Yes, Mr. Dutta.
Your lordship, there is the order they have challenged. There is a direction of pay in recovery, and the owner has been struck off in this appeal. So they filed this appeal for enhancement. So that will also affect the owner, because we will recover it from the owner. So I think they are a necessary party here, the owner, which is the respondent number 1 in this appeal.
Owner is not made a party in this proceeding.
No, your lord. No,
No, owner's party, my lord.
Struck off as per order dated
When?
15/7/2024.
As because, my lord, getting of judgments of Honorable Supreme Court, the criteria is these. First, satisfied the award by the insurance. And that is the duty of the insurance to recover from the owner. And if owner is there, then also judgment is same. That is their duty to recover from the owner. There is no any scope for suffering the claimant. Claimants the entitlement to compensation. How they recover, that is their
They have
duty.
not contested the proceeding before the tribunal.
Beg
This,
your pardon, your lord.
driver and owner.
No, your lordship did not contest.
In that And
Suggest me whether there is any chance of settlement in the.
yes, every chances is there, my lord.
Your lordship, we have no objection, but the owner might have. And they have been.
No,
stuck-
he's
Owner is not
he
there.
has not contested the proceeding before that.
Yes, your lordship.
Let it go to the
Okay.
mediation. See,
Much.
parties have to appear before the.
Before mediation on,
Mediator.
mediator on 12 September, 12 August,
Well,
and fixed on 8 September.
for report. Report.
My lord, earlier one date was not, my lord. Item 8 not, date was not given.
Item
No, 8.
8.
8.
Date the same. Date the same.
7.
Much of.
Of like,
Admission, item number
11.
11 by BC.
My lord, the lead counsel, he's on his legs. My lord, it may be passed over for a short while.
Who is the counsel?
Mr. CP Sharma, my lord. Senior counsel. My lord, this is that matter arising out of Vishwanath Charali, my lord, where the judgment has been passed against us and we were never made a party to the proceedings, my lord, in the land acquisition proceeding, reference matter, my lord. This had come up on the previous date, my lord. And on Thursday, my lord, and then my lord has fixed it for today. My lord, it may be passed over for 15 minutes, my lord. He's on legs. My lord, we were never made a party to the whole proceedings which had happened. And post award of the judgment, my lord, now they have filed for execution where we are being made liable to pay the decreed amount, my lord. During the course of
After some time?
Yes, lordship. No problem.
Item number 12.
None appears for the petitioner on call. Place the matter after 2 weeks.
For hearing, item number 13.
13 to.
Wait, is it lordship? Lordship, on appearance for all the respondent lordship. Respondent number 1, she expired on 24/3/2025, lordship.
No, he pressed for an adjournment.
Lordship, substitution petition has to be filed, lordship.
No,
Respondent
that's
number
all
1,
right. He pressed for adjournment of the case.
lordship.
As agreed by learned advocates of both the parties, SSL is the matter. When?
No, sure, after 4 weeks,
After?
4 weeks.
No. After 2 weeks. This is of 2011 matter.
Okay, Lord.
After 2 weeks.
Obliged, lordship.
Item 15.
14.
Item 15.
May I please, your lordship? My lord, this matter was earlier heard by lordship and it was also kept part heard, my lord. During course of argument, my lord, learned opposite party learned friend has informed this court that appellant number 1 died, my lord. At that time, I had no information regarding his death, my lord. There is another appellant, my lord, appellant number 2 also, wife of the appellant number 1, my lord. Now, my lord, petitioner appellant number 2 will pursue the matter, my lord. This appeal will be pursued by appellant number 2, my lord. And in this regard, my lord, I have got a judgment of the full bench court of Honorable Kolkata High Court, my lord. Therein, my lord, it is clearly stated, my lord, that my lord, at the stage of appeal also, if appellant dies, my lord, and his legal representatives are not represented, my lord, then remaining appellant can proceed with the case, my lord. So on this basis of judgment, my lord, the lordship may proceed with this appeal also, my lord.
Yes,
I have no objection, my,
no objection.
no objection.
Okay. Heard me, sir?
Yes,
Your
sir.
name, please.
I.S. Laskar.
I.S. Laskar, learned counsel for the appellant, and Mr. Kadir for respondent.
My lord, the matter may be hard today, my lord. Matter may be hard today itself.
Today,
Yes.
I am ready, my lord, if Lordship hears it.
the learned counsel for the appellant submits that during the course of hearing, it has come to his notice. No, he came to know that the appellant number 1, Horekisno Raha, suffered demise. And the appellant number 2 will pursue appellant number 2, who happened to be the wife of the appellant number 1, will pursue the matter. And there is no requirement for pleading no other legal heirs. They have no son and daughter.
Son and,
As per our information, there was a son. As per my instruction here.
Okay.
Lordship.
but
He is not required to be impleted here.
his legal representative, my lord, he's not willing to get himself represented, my lord. His
Okay.
mother, since my lord, the fact is that, my lord, deed was purchased by appellant number 2, mother, my lord. So if mother succeeds, my lord, then she will get the land in her name, my lord. So that's why son is not interested, my lord.
Okay. Though Horekisno Raha left behind one son, he is not willing to pursue the appeal. With the legal heirs. And therefore, the appellant number 2 will pursue the appeal. Okay. Argue the matter.
Yes, my lord. My lord, initially, my lord, case was admitted on 2 substantial question of law, my lord. That one was, my lord, it was on 22 February 2016, my lord, that order was.
Yes.
Whether the learned appellate court below was justified in drawing an adverse presumption under section 114 of the Indian Evidence Act against the present appellant defendants, despite the failure of the prosecution side to discharge its burden of proof, my lord. That is one, my lord. And second thing is that, my lord, whether the learned lower appellate court below was correct in interfering with the findings of the learned trial court below by holding the sale deed number 845 dated 1990, my lord, exhibit 6 as a fraudulent one, my lord. My lord, gist is that, my lord, fact, I'm telling Lordship the only simple fact, my lord, that Lordship may go through the findings of the trial court. My lord. Trial court has dismissed the suit, my lord. Suit was filed by the present respondent plaintiff, my lord, and it was dismissed by the trial court. Thereafter, they filed appeal, my lord. Appeal was reversed, my lord. In appeal, findings was reversed, my lord. Against the reversal finding, we have come before this honorable court, my lord. Lordship may kindly come to the judgment at page 41, my lord. Trial court's judgment, my lord. Fact is given there.
Page number?
Page 41, my lord. It starts from page 42.
Yes.
This is a suit for declaration of title, confirmation of possession, and cancellation of sale deeds.
Okay.
Plaintiff's case in nutshell.
Yes.
Plaintiff's case in nutshell is that the second arrest party number 27 was originally issued in the name of the predecessor of the defendant, namely Sudhanna Mohan Raha. That while Sudhanna Mohan Raha was the owner and possessor of the suit pata, he sold 13 katas of land to the predecessor of the plaintiff, namely Madhusudan Pal, my lord. This is admitted fact. We are also admitting that our predecessor initially sold 13 kathas of land to their predecessor, my lord. By registered sale deed. That subsequently the predecessor of the plaintiff also purchased 1 katha, 3 chathak, 10 gondas of pathway type land from the predecessor of the defendant. That part also we are admitting, my lord. We sold them, my lord. Thereby, the predecessor of the plaintiff purchased total land 14 kathas, 3 chathak, 10 gondas from the predecessor of the defendant. This is admitted, my lord. That the said pathway type of land is situated on the adjacent eastern boundary of the earlier purchased land of 13 kathas. The predecessor of the plaintiff sold 3 kathas of land to one Shankar Ranjan Das and delivered possession to him. Therefore, the predecessor of the plaintiff remained owner of 11 katha, 3 chathak, 10 gondas of land. Madhusudan Pal died on 13/9/1997, leaving behind the plaintiff and his sole heirs, who became the owner of the above land by way of right of inheritance. That on the death of husband, the plaintiff number 1 left the suit premises along with his sons and started residing elsewhere in search of avocation. The plaintiff occasionally visits the suit premises and maintaining the suit land by putting bamboo fencing around it. He also sells the sungrass grown on the suit land. Accordingly, on 1/6/2005, when the plaintiff by engaging labor putting bamboo fencing around the suit land, the defendants opposed the said work and tried to attack the plaintiff with lethal weapon. The plaintiff, apprehending the danger, immediately apprised the matter to the nearby people, and they came and rescued the plaintiff, and seeing that the defendants had fled away, but they leave with a warning that they will come again. The plaintiff also informed the matter to the Gao Panchayat. Subsequently, the plaintiff compelled to file proceeding under section 144 CRPC that the aforesaid act of the defendant clouded the right, title, and interest of the plaintiff. In that proceeding, the plaintiff surprisingly come to know that the second party allegedly purchased the whole land from the predecessor of the plaintiff's side. This is important, my lord. Registered sale deed. The plaintiff obtained a certified copy and come to know about the sale. The plaintiff claimed that his predecessor, except the land of 3 kathas, never sold any land to any person. The so-called sale is forged and fraudulent, hence he filed the suit. Initially, my lord, by 2 sale deed, my lord, defendant's predecessor sold to the plaintiff's predecessor, totaling 14 kathas and 3 chathak, 10 gondas land. By 2. Subsequently, my lord, appellant number 2, my lord, she purchased the same land from the predecessor of the plaintiff, my lord. Now, on next page, my lord, on summons, the defendant appeared in the suit and filed written statement. Defendant denied all the allegation of the plaintiff. The defendant admits that the predecessor of the plaintiff, Madhusudan Pal, purchased total area of 14 katha, 3 chathak, 10 gondas of land from the predecessor of the defendant, Sudhanna Mohan Raha. The said Sudhanna Mohan Raha, Madhusudan Pal, transferred the land to the defendant number 2. Defendant number 2 is present, appellant number 2, for favorable consideration, and since then, the defendant number 2 is possessing his purchased land, her purchased land. The defendant claimed that his purchase deed is valid and genuine, and the plaintiff, fully knowing the real fact, making false statement at the instance of the persons inimical to the defendant, and filed the instant false case, false suit. Hence, the defendant prayed to dismiss the suit. Now, my lord, question is that this exhibit 6, my lord, this is that whether the same land was again retransferred to the appellant number 2, my lord, defendant number 2 or not. Whether defendant number 2 again purchased the same land from the father of the plaintiffs or not, my lord. That is that deed is under challenge, my lord. They have challenged that deed for cancellation of deed, saying that it is forged, fabricated, my lord. Now, court has to see whether it is false or fabricated. They have sufficiently proved or not, my lord. That but the entire dispute is connecting with this deed, my lord. On pleading, the following issues are framed: whether there is a cause of action of the suit, whether the suit is maintainable in its present form and manner, whether the suit is bad for defects of parties, whether the plaintiff has right, title, and interest, whether the plaintiff has possession over the suit land, whether the sale deed registered on 4/12/1990 is illegal, fraudulent, and liable to be cancelled. To what relief the parties are entitled to. During trial, the plaintiff side adduced 2 witnesses and also exhibited some document. The defendant has not submitted any evidence. Discussion, decision, and reason for such decision. Issue number 4, 5, and 6, my lord. That whether plaintiff has right, title, interest, whether the plaintiff has possession over the suit land, whether the sale date registered is illegal, fraudulent, and liable to be concerned or not, my lord. These three issues are vital issues, my lord. These are decided initially, my lord. As these three issues are very vital issues and interrelated to each other, so these issues are taken together for discussion. It is admitted fact that predecessor of the plaintiff, Madhusudan Pal, purchased total land of 14 katha, 3 chathak, 10 gondas of land from the predecessor of the defendant, Sudhanna Mohan Raha. But the boon of contention is that plaintiff alleged that on the death of husband, the plaintiff number one left the suit premises along with his sons and started residing elsewhere in search of avocation. The plaintiff occasionally visit the suit premises and maintaining the suit land by putting bamboo fencing around it. He also sell the grass grown on the suit land. Accordingly, on 1/6/2005, when the plaintiff by engaging labor putting bamboo fencing around the suit land, defendant opposed the said work and tried to attack the plaintiff with lethal weapon. The plaintiff, apprehending the danger, immediately apprised the matter to the nearby people, and they came and rescued the plaintiff. And seeing that the defendants had fled away, thereafter the plaintiff come to know that the defendant allegedly purchased the whole land from the predecessor of the plaintiff by registered sale deed. The plaintiff obtained a certificate copy and come to know about the sale. The plaintiff claimed that his predecessor, except the land of 3 kathas, never sold any land to any person. The plaintiff claimed that the said purchase is illegal and fraudulent. On the other hand, the defendant claimed that the predecessor of the plaintiff sold out the suit land to the defendant number 2. The plaintiff appeared as PW1 and deposed in support of her claim. But in the cross-examination, she could not answer the relevant question, which is very vital in the suit. PW1 in her cross replied that she cannot say if the defendant has submitted their written statement or not. She cannot say anything in respect of the suit land except the sale to Shankar Ranjan Das. She cannot say the suit patta number, the total land of the suit patta, who possessing what land. She cannot say anything about the subject matter of the suit. She cannot say anything about the subject matter of the suit, my lord. PW2 in his cross replied that he cannot say as to who filed the case. He cannot say in whose favor he come to depose, my lord. The suit land is situated at a distance of 2.5 kilometers from his house. He cannot say who is possessing how much land in Dudpatil. He is deposing as per the version of his auntie-in-law, that is PW1, my lord. From the cross of PW1 and 2, it is crystal clear that they do not know anything about the suit. During argument, learned counsel for the plaintiff submitted that the case of the plaintiff is proved as per the document, and as the defendant has not come to the witness box, so he avoided pertinent question which would be asked by the plaintiff. In light of this fact, the case of the plaintiff should be decreed. The learned counsel for the defendant submitted that the plaintiff must prove his case by leading evidences. The defendant placed one citation reporting in AIR 1956, Supreme Court 66. I peruse the citation. The Honorable Apex Court held a true judicial decision presupposes an existing dispute between 2 or more parties and then involves 4 requisites: representation of their case by the parties to the dispute. If the dispute arises between them is a question of fact, the ascertainment of the fact by means of evidence adduced by the parties to the dispute, and often with the assistance of argument by or on behalf of the parties on the evidence. If the dispute between them is a question of law, the submission of legal arguments by the parties and a decision which disposes of the whole matter by a finding upon the facts in dispute and an application of the law of the land to the facts so found, including where required a ruling upon any disputed question of law. It is established that the party on whom the burden of proof lies shall adduce the evidence in support of his case to prove the fact of that case. When a witness deposed in support of his case, then to check the veracity of his statement, the other side is given the opportunity to cross-examine the witness to check the credibility of the witness. The examination in chief as well as cross-examination together form the evidence basing on which court is to come to a proper conclusion. In this suit, the plaintiff claimed that she has right title and confirmation of possession and for cancellation of the sale deed, but her deposition in chief has been fully destroyed in the cross. There is no scope left for the court to accept what the plaintiff deposed in her examination in chief. In light of above discussion, I therefore held that the plaintiff could not establish her case by leading sufficient evidence, nor she could establish that the sale deed is a fraudulent and illegal. Hence, I opine that the plaintiff has no right title and possession over the suit land, and the plaintiff also failed to establish that the sale deed is not illegal or fraudulent. All these 3 issues are answered in negative and decided against the plaintiff. So these major main issues are decided, and this is the findings of the trial court. Evidence from the evidence of PW1 and 2, they could not establish anything doubting our deed, my lord. So, my lord, they have failed to discharge their initial burden of proof, my lord, regarding alleged fraudulent deed, my lord. Now, my lord, we come to the findings of the appellate court, my lord. Page 55, my lord, appellate court's finding.
Yes.
Yes, my lord, we may start from page 57, my lord. Issues, my lord. Whether there is cause of action for the suit, whether the suit is maintainable in the present form and manner.
No, no, those issues are framed by the trial court.
Yes, my lord. Yes, fact is from
No,
page.
no, those issues are already
Yes,
framed
yes,
by
my
the
lord.
trial court.
During the trial of the suit, during trial of the suit, the plaintiff side adduced evidence of 2 PWs and exhibited some documents. The defendant adduced none. Upon closure of both sides' evidence, the learned court heard argument by passing the interim judgment and decree dismiss the suit of the plaintiff. Aggrieved by and dissatisfied with such dismissal, plaintiff preferred the appeal. During pendency of this appeal, my lord, appellant side adduced additional evidence. Another PW3 had adduced evidence, my lord, during appellate stage, my lord. And the respondent side took full scope for cross-examination. Upon closure of additional evidence, I have heard argument advanced by learned advocates of both sides. There appears no dispute of the fact that by 2 documents, Exhibit 1 and 2, Madhusudan Pal, the predecessor of the appellant's plaintiffs, purchased 14 Katha, 3 Chatak, 10 Gondas land in the Shoot Patta and Dag from Sudhanna Mohan Raha, the predecessor in interest of the respondent defendants. In the suit, where the appellant's plaintiffs claimed that their predecessor sold only 3 kathas of land to one Shankar Ranjan Das and did not sell any other land, the respondent defendants claimed that the Madhusudan Pal sold his entire interest of 14 katha, 3 chatak, 10 gondas in favor of the respondent defendant number 2 by registered deed number 845. Thus, the crux of the dispute between the litigating parties is over the question whether the registered deed number 845 is fraudulent or not. Hence, the following point is taken up for determination in this appeal. Point for determination, whether deed number 845 is fraudulent or not. This is the crucial issue, my lord. In the suit, the plaintiff have prayed for a decree of declaration of their right, title and interest over suit schedule 1 land, confirmation of possession thereon, and cancellation of registered deed number 845. The plaintiff side has proved in the record the purchase deeds of their predecessor Madhusudan Pal by Exhibit 1 and 2. These documents are original registered sale deeds dated 5/8/1986 and dated 13/7/1987 respectively. Then Exhibit 1 and Exhibit 2 are undisputed documents. Exhibit 1 shows transfer of right, title, interest and possession of 13 katha land, and Exhibit 2 shows transfer of 1 katha, 3 chatak, 10 gondas, in total 14 kathas, 3 chatak, 10 gondas of land in the Shoot Patta and Das within specific boundaries by the predecessor in interest of the defendant in favor of the predecessor in interest of the plaintiffs. The plaintiffs have also exhibited the original sale deed executed by Madhusudan Pal on 12/5/1987 in favor of Shankar Ranjan Das by Exhibit 3, my lord. My lord, though it is written that, my lord, exhibited original sale deed, my lord, BW1 in our deposition saying that xeroscopy was exhibited, my lord. Anyway, plaintiffs have also exhibited the original sale deed exhibited by Madhusudan Pal on 12/5/87 in favor of Shankar Ranjan Das by Exhibit 3. Exhibit 3 is duly proved by Shankar Ranjan Das himself. After acquiring the title over 13 kathas land in the Shoot Patta and Dag, the predecessor in interest of the plaintiff transferred by sale 3 kathas of land in the Shoot Patta and Dag in favor of Shankar Ranjan Das by Exhibit 3. So after sale, Madhusudan Pal's interest is reduced to 10 kathas, that is 13 minus 3 on 12/5/87. Thereafter, On 13-10-87 by Exhibit 2 said Madhusudan Pal purchased another 1 katha, 3 chatha, 10 gondas in the shoot patta and that from the previous interest of the defendants. And after such purchase, his total interest is increased from 10 to 11 katha, 3 chatha, 10 gondas on 13-10-87. Thus it appears after sale to Shankar Ranjan Das, Madhusudan Pal was having right title, interest and possession over 11 katha, 3 chatha, 10 gonda of land in the shoot patta and dag on 13-10-87. The registered document number 845 is proved in the record by the Exhibit C. Exhibit 6 shows sale of 14 katha, 3 chatha, 10 gondas of land in the shoot patta and dag by Madhusudan Pal in favor of defendant number 2 on 5/11/1990. We have already seen above that 13-10-87 Madhusudan Pal's right interest, title interest and possession in the shoot patta was reduced from 14 kathas, 3 chatak 10 gondas to 11 katha, 3 chatak 10 gondas. In such a situation, by Exhibit 6, right title interest and possession over 14 katha, 3 chatak 10 gondas cannot be legally transferred by Madhusudan Pal in favor of the defendant number 2. On the other hand, the answering defendants have not come up with any evidence in support of their claim of purchase of the scheduled mentioned land of the WS from Madhusudan Pal, where Madhusudan Pal had no right title, interest and possession over 14 katha, 3 chatha, 10 gondas of land in the shoot patta and dag and the Exhibit 6 cannot convey right title, interest and possession over 14 katha, 3 chatha, 10 gondas of land in the shoot patta, and in the absence of proof of execution of such document by Madhusudan Pal, we are left in no hesitation that the said document is fraudulent. Fraudulent based on court has come to the conclusion that there was not 14 kathas, 3 kathas were sold. So it was a fraudulent document, my lord. If Madhusudan, my lord, petitioner of the plaintiff, they fraudulently sold us 14 kathas, but originally there is 3 kathas less than 3 kathas, then can it be termed as fraudulent, my lord? Our purchase can be termed as fraudulent, my lord. Learned appellate court is saying that there was 14 kathas was not there. So this is fraudulent, my lord. Not from the evidence of PW 1 and 2, my lord, but by simply calculating that out of 14 kathas, my lord, 3 kathas were sold to one another person, my lord, and there was not 14 kathas of land. So petitioner of plaintiffs cannot sold 14 kathas, my lord. Cannot be justified, my lord. So remaining portion, then if 3 kathas are sold, then they will be entitled for 11 kathas, my lord, suppose, but cannot be termed it as illegal, my lord, collusive and, my lord, fraudulent, my lord. Document has to be proved whether it is fraudulently obtained or not. That has to be proved on evidence, my lord. But they are playing tricks on us, my lord. If they are playing tricks on, they cannot be allowed to take advantage of that, my lord. They are selling us lesser land, my lord. If suppose, my lord, they cannot be allowed to get advantage of that, my lord. So, learned appellate court has come to a wrong finding, my lord. Simply on the basis of that, there was not 14 kathas of land, so it was a fraudulent transfer, my lord. So, now again I am continuing, my lord. The learned advocate for the defendant respondent vehemently argued that where the cross-examination of all the PWs, including the plaintiffs number 1, has exposed their ignorance, it is enough to reduce the suit to the ground. Refuting the arguments, learned advocate for the appellant, plaintiffs argued that oral evidence in a civil suit is not much material as the documentary proof, and the learned lower court committed illegality in not taking into consideration the document proved in the record. Bearing in mind the argument, if we go through the evidence on record, it is found that in a suit where right title and interest is subject matter of dispute, oral evidence has little weight in determining the fate of the suit. Rather, the documents proved in the record will prevail over the oral evidence, and ignorance on the part of the PWs regarding the suit and the suit land has little bearing in deciding the fate of the suit, my lord. A perusal of the impugned judgment is transferred that it has not discussed and relied upon the documentary proof in arriving at a decision of the suit. The whole approach of the lower court appears to be not sustainable in the eye of law. Where the plaintiffs by documentary proof have been able to establish the fact that on the date of alleged execution of Exhibit 6, vendor did not have right title, interest and possession over 14 kathas, 3 chasas and 10 gondas of land. It was the duty of the defendant respondent to adduce evidence proving execution of the said deed by Madhusudan Pal, or that on the date of execution of the Exhibit 6, the vendor had right title, interest and possession over those 14 kathas, 3 chatak and 10 gondas of land. Rather, the defendant respondent did not appear in the witness box to prove their case. In the case law reported in the AR 1973 Guwahati 90 relied upon by the appellant plaintiff, it is held that when a party to a suit avoids the witness box, presumption is that he is withholding himself to avoid pertinent questions in cross-examination. In this case, also where the defendant claimed right title, interest, and possession over the suit scheduled land by purchase from Madhusudan Pal, they ought to have adduced evidence proving execution as well as the genuineness of the exhibit 6, but they refrained themselves. In such a situation, an adverse presumption lie against their case under Section 114 Evidence Act. Accordingly, we are left in no hesitation that the Exhibit 6 is an illegal and fraudulent document, as such the point in hand is decided in the affirmative. Admittedly, Madhusudan Pal was having right title, interest, and possession over 14 kata, 3 kata, 10 gandas of land in the Sud Patan Dag. It is proved in the record that out of said 14 kata, 3 kata, 10 gandas, he transferred by sale 3 katas of land in favor of one Shankar Ranjan Dar. So after such sale, he had right title, interest, and possession over 11 kata, 3 kata, 10 gandas of land in the Sud Patta. Exhibit 6 being proved in record to be fraudulent and liable to be cancelled, the plaintiff as legal heirs and successors of deceased Madhusudan Pal have right title, interest, was a possession over 11 kata, 3 kata, 10 gandas of land in the Sud Patta and Dag, my lord. So, my lord, this is the findings, my lord. Huh? Now, my lord, lordship, we will go to the evidence, my lord. What is there in the evidence, my lord? My lord, earlier lordship is directed for translation of this evidence, my lord. Cross-examination part, my lord. So, that was Bite Order 88/2024. PW 1, 2, and 3. Translation. Okay.
Schedule 1 and 2 are here.
1 or 3 is in English, my lord. 1 and 2, my lord.
Okay. Yes.
Yes, but my lord, I am having vernacular part. I have not been given that English part, my lord. So I may have to read Bengali vernacular evidence, my lord. Or lordship may see from translated part, my lord.
Okay.
I'm reading, okay. PW 1, my lord. Pratibha Sundari Pal. আমি ছোট লেখা পড়িতে পারি না। আমি আজ থেকে 12 বছর যাবৎ চোখে দেখি না। আমি ক্লাস 6 পর্যন্ত লেখাপড়া করিয়াছি। আমি ইংলিশ লিখিতে পড়িতে পারি না। আমি শঙ্কর রঞ্জন দাসের 12/5/87 ইংরেজি তারিখে দলিলের জেরক্স কপি দাখিল করিয়াছি। Xerox copy was submitted, my lord. That they sold 3 katas Xerox copy, but appellate court is recording that original copy, my lord. So original copy was not submitted, my lord. It was also not proved whether they actually sold or not, my lord. And Shankar Ranjan Das is the PW3, my lord. From his deposition, my lord, it will be clear, my lord, whether he purchased or not, my lord. I am coming to that point. আমি শঙ্কররঞ্জন দাসের 12/5/87 ইংরেজি তারিখে দলিলের জেরক্স কপি দাখিল করিয়েছি। এই জেরক্স কপি এক্সিবিট 4 মার্ক করা আছে। আমি সরকারি চালানের জেরক্স কপি দাখিল করিয়েছি আর এক্সিবিট 8 সিরিজ হিসাবে মার্ক করিয়েছি। ওই এক্সিবিট 4 আর এক্সিবিট 8 আমার বড় ছেলে জেরক্স করিয়েছে। এক্সিবিট 3 কোনো সার্টিফিকেট কপি আমি বাহির করি নাই। এই মোকদ্দমায় এক্সিবিট 3 কোনো সার্টিফিকেট কপি আমি বাহির করে না। দ্যাট মিনস দ্য এক্সিবিট 3 এনিওয়ে মানে সার্টিফিকেট আমি বাহির করে না। এই মোকদ্দমার বিবাদীরা জবাব দিয়েছে কিনা আমি জানি না। আমি শঙ্কররঞ্জন দাসের নিকট বিক্রয় করা ছাড়া এই মোকাবিলা সম্পর্কে কোনো কিছুই বলিতে পারিব না। She is absolutely unaware of anything, my lord. They are challenging our deed, sale deed, and saying that we don't have any idea regarding the suit, my lord. এই মোকদ্দমার জমির পট্টা নং আমি বলিতে পারিব না। নালিশা পাট্টায় মোট জমি কত, কে কোন জমি দখল করিয়া আছে তা আমি বলিতে পারিব না। দুধপাতিল হইতে আমার বাসস্থান ঘুঙ্গুর আনুমানিক 14 মাইল দূরে। 2 নং বাদী 2-3 বছর যাবৎ গুয়াহাটিতে কর্মরত। আমরা বাদীরা এই মোকদ্দমার বিষয়বস্তু কিছু বলিতে পারিব না। আমি প্রফুল্ল রাহাকে চিনি, আমি বিনয় সরকারকেও চিনি। ইহা সত্য নয় যে আমি সেটার জেরক্স কপি এক্সিবিট করিয়াছি, তাহা আইনমত গ্রহণযোগ্য না। আমি উৎপল রায়কে চিনি। So, my lord, nothing there in the deposition of PW1, my lord. Substantiating our document as fraudulently obtained, my lord. Our sale deed, my lord, regarding our sale deed, my lord, she's totally ignorant. She has no idea, my lord. Nothing said against our deed, my lord. PW2, my lord, I'm coming. Chandan Dushad, my lord. He is a relative of PW1, my lord. আমি যে জমি নিয়ে সাক্ষী দিতে আসিয়াছি, সেই জমির স্থান দুধপাতিল বাজারে ছড়া আমার নিজা কোনো জমি নাই। আচ্ছা, মধুসূদন পালের সঙ্গে আমার কি ধরনের আত্মীয়তার সম্পর্ক তাহা আমি আমার মুখ জুবান বন্দিতে উল্লেখ করি নাই। এই মোকদ্দমা কে করেছে আমি বলিতে পারিব না। হি ইজ এগেইন সেইং দ্যাট হু হ্যাজ ফাইলড দিস স্যুট আই ক্যানট সে। এই মোকদ্দমা কি কি কাগজপত্র দাখিল হইয়াছে তাও বলিতে পারিব না। আমি কোন দলিলের সাক্ষী নই, আমি কোনো দলিলের সাক্ষী নই। আমি অত্র আদালতে কার পক্ষে সাক্ষী দিতে আসিয়াছি তার নাম বলিতে পারিব না। দুধপাতিল বাজারি চড়া আমার বাসস্থান হইতে 2-2.5 কিলোমিটার দূর। আমি ইংরাজি লেখাপড়া জানি না। আমি আমার পিসি শাশুড়ির কথায় কোর্ট আসিয়া সাক্ষী দিতে। পিসি শাশুড়ি, PW1 ইজ পিসি শাশুড়ি, মাই লর্ড, মাদার ইন ল, মাই লর্ড। কোর্টে আসিয়া সাক্ষী দিতেছি। এই মোকদ্দমা সম্পর্কে আমার ব্যক্তিগত কোনো জ্ঞান নেই। No, PW3, my lord. His deposition was taken at the appellate stage, my lord, first appellate stage, my lord. Shankar Ranjan Das, who allegedly purchased 3 kathas of land, my lord.
Is it part of the record?
My lord, yes, yes, sir.
Page number.
Evidence আছে, record আছে, deposition আছে, PW3 deposition.
PW3 deposition, my lord, that is
Record.
that may be on record, my lord.
I think it is on file C, page number 45, file C, my.
আমারও মিলা নাই, কাটি
Page number 45.
মিলা নাই।
Auto record.
Page number 40.
Page number 45 is my record. File C.
Yes.
PW3, Shankar Ranjan Das. I used to stay at Bilpar, Silchar town permanently with my family members. I am staying in a rented house under Radha Madhav Akhara, Bilpar. I have no document to show that I am a monthly tenant of Radha Madhav Akhara. I cannot read and write English. I can read Bengali. I was not present at the time of hearing of the original suit. I was taken to lawyer by Pratibha Rani Pal. I was taken to lawyer by Pratibha Rani Pal. The Pratibha Rani Pal is PW1, my lord. The examination in chief is written at the instance of Pratibha Rani Pal. Examination in chief is written at the instance of Pratibha Rani Pal. Exhibit 1 is the sale deed of Madhusudan Pal. I have mentioned in my examination in chief that Exhibit 1 is dated 8/5/86. In Exhibit 1, the date of execution is written as 5/8/86. I cannot say the holding number of rented house in which I am residing with my family members. I cannot say the total number of dags of the Sud Patta. I cannot say the total area of land covered by the Sud Patta. I cannot say the area of land possessed by different persons in the Sud Patta. I cannot say the area of land covered by the Sud Dag. I cannot say the deeds in respect of which I have stated in my examination in chief. This is very vital, my lord. I cannot say the deeds in respect of which I have stated in my examination in chief, even in connection with his deed, purchase deed, my lord. The plaintiffs are saying that they sold 3 cutters of land to him, my lord, and he is staying somewhere in a rented house, my lord. Had he really purchased, my lord, he could have stayed there in his own land, my lord. Now, in cross-examination, he said, I cannot say the deeds in respect to which I have stated in my examination as chief. So, in examination chief, his deed is also there, my lord, and he is saying in cross that I cannot say anything. So, he has not purchased 3 cutters of land also, my lord. That is also doubtful, my lord. I am not attesting witness of any of the deeds I have mentioned in my examination in chief. I cannot say whether my examination in chief was written by hand or it was typed. I cannot say whether and how my examination in chief was written. So examination of chief was written at the instance of Pratibha Rani Pal, my lord. That is plaintiff, my lord. So, my lord, now, my lord, from the entire evidence, my lord, it is clear that, my lord, that the plaintiff side has absolutely failed to prove, bring any doubt regarding our purchase deed, my lord. So, in this regard, my lord, I am relying on some case laws, my lord. Okay, my lord.
On the other day, you have submitted some of the case laws.
Yes, my lord.
The civil appeal number 4413 to 4414.
Civil appeal number, civil appeal number.
Civil appeal number.
Shobha Hemavati Devi versus Seti
Yeah.
Gangadhara Swami.
Year 2005.
It could be there. Lord, like, you know, 1973 Gujarat, 1972 Gujarat, you know.
Anil Rishi. Anil Rishi. Decide.
আরোটা হয়ে গেল না
এইটুকু সুন্দরলাল বানাপাটি
এইটুকু কিতাব আচ্ছা এইটুকু দিন ইয়েস ম্যাডাম
2007 plus it up. 7.
Yes. First, my lord, I am relying on AIR 2005, Supreme Court 800, my lord. Paragraph 6, my lord. It says, my lord, it says, my lord, normally presumption can be drawn, my lord. Adverse presumption can be drawn, but it is rebuttable, my lord. And if there are circumstances weakening such presumption, cannot be ignored by the court, my lord. So, my lord, learned appellate court below has come to the adverse presumption by only by not coming to the witness box by any witness, my lord. That was not necessary even, my lord. It is a document to be proved, my lord. So, documentary evidence in that has not been shaken, my lord, that part, my lord. So, in his absence to depose any, my lord, lapse to come before the witness box, it is not fatal, my lord. So, my lord, that adverse presumption, my lord, circumstances, all these circumstances weakening the such presumption cannot be ignored by the court, my lord. That is what Supreme Court has said in this decision, my lord. My lord. Then again, my lord, there is 1973 Gujarat 57, my lord. Shrajan Raj Swarup Chand versus Mehta Commercials, my lord. In paragraph 9 also, my lord, it is said that unless it is established that in spite of the defendant being in custody of the books of account, had deliberately omitted to produce the same for some ulterior motive, no adverse inference can be drawn against the defendant, my lord. Now, my lord, ulterior motive must be proved, my lord, for absenting someone or producing any document, my lord. If that motive part is not proved, my lord, this is again, my lord, Gujarat High Court is saying that motive part, if ulterior motive part is not proved, my lord, that in that case also, my lord, adverse inference cannot be drawn, my lord. So that is what in paragraph, my lord, 9 it has said, my lord. And I am also relying another, my lord, that is 2000, that is Supreme Court, my lord. Supreme Court decision. I have got the book, my lord. So, that I could not, I am only having this book, my lord. Just morning, my lord, I have collected it. In this is, my lord, AIR 2007, Supreme Court 590, my lord. Section 114 of the Evidence Act, my lord. Adverse inference, my lord. Paragraph 84, my lord. Paragraph 84, my lord, it says ordinarily it can be drawn, adverse inference can be drawn in respect of allegation, not traversed. But rule is not that adverse inference must always be drawn, whatever facts and circumstances may be, my lord. Normally, my lord, adverse presumption can be drawn, my lord, if that is not countenanced or not traversed, my lord. But such adverse inference must always be, rule is not that adverse inference must always be drawn, whatever facts and circumstances, my lord. So in our facts and circumstances, my lord, it is absolutely error committed by appellate court by drawing adverse inference under 114 of Evidence Act, my lord. Simply not coming to the witness box, my lord. Burden lies on them, my lord. On the plaintiff, my lord. They have not discharged initial burden, initial honors, my lord. So on that basis, my lord, they should have discharged their burden, my lord. Now, my lord, on the point of, my lord, burden of proof, my lord, that is, I have citation is, my lord, AIR 2006, Supreme Court 1971, my lord.
Yes.
Yes, my lord. Paragraph 8, my lord. I am reading paragraph 8, my lord. Initial burden of proof would be paragraph 8, my lord. Initial burden of proof would be on the plaintiff in view of section 101 of the Evidence Act, which reads under section 101 burden of proof, where whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. In terms of the said provision, the burden of proving the fact rests on the party who substantially asserts the affirmative issues and not on the party who denies it. The said rule may not be universal in its application and there may be exception thereto. The London Trial Court and the High Court proceeded on the basis of the defendant was on the basis that the defendant was in a dominating position and there had been a fiduciary relationship between the parties. The appellant in his written statement denied and disputed the said averments made in the plaint, my lord. Pleading is not evidence. Far less proof issues are raised on the basis of the pleadings. The defendant appellant having not admitted or acknowledged the fiduciary relationship between the parties, indisputably, the relationship between the parties itself would be an issue. The suit will fail if both the parties do not adduce any evidence in view of Section 102 of the Evidence Act. Thus, ordinarily, the burden of proof would be on the party who asserts the affirmative on the issue, and it rests after evidence is gone into upon the party against whom at the time of the question arises, judgment would be given if no further evidence were to be adduced by either side. My lord, again, my lord, paragraph 19, my lord, lordship may come to paragraph 19. There is another aspect of the matter which would be borne in mind. A distinction exists between a burden of proof and onus of proof. The right to begin follows onus probandi. It assumes importance in the early stage of a case. The question of onus of proof has greater force, where the question is which party is to begin. Burden of proof is used in three ways: to indicate the duty of bringing forward evidence in support of a proposition at the beginning or later, to make that of establishing a proposition as against all counter evidence, and an indiscriminate use in which it may mean either or both of the others. The elementary rule is Section 101 is inflexible. In terms of Section 102, the initial onus is always on the plaintiff, and if he discharges that onus and makes out a case which entitles him to a relief, the onus shifts to the defendant to prove those circumstances, if any, which would disentitle the plaintiff to the same, my lord. So, my lord, in the present case, my lord, they have absolutely failed to discharge their initial burden, my lord. So, under 101, Section 101 and 2 also, my lord, they have not
Okay.
discharged their.
Okay. Yes.
So your lordship gone through the facts, your lordship. And now if we come to the substantial question of laws regarding my lord, the presumption, the statutory presumption. Section 114, my lord, of the Evidence Act.
Yes.
My lord, Section 114G, my lord. The court may presume the existence of any fact which it thinks like to have happened regard being had to the common course of natural events, human conduct and public and private business in their relation to the facts of the particular case. This G, my lord. The evidence which could be and is not produced would, if produced, be unfavorable to the person who withhold it. So this statutory presumption, my lord, since the defendants have not adduced any evidence, and they have based their case only on the weakness of the plaintiffs. That is not, my lord, permissible as per law. My lord, what happens? The learned trial court, the based its judgment only on the oral evidence. So regarding the oral evidence, my lord, that Section 91 and 92 of the Evidence Act regarding, my lord, the documentary evidence always prevails over the oral evidence. Though there is some defaults on the part of the plaintiffs, my lord, in their oral evidence, my lord, but the exhibits, my lord, they exhibited, I will, my lord, place two judgments regarding, my lord, the may I read in this regard, my lord, the Section 91 of the Evidence Act. Regarding the documentary evidence prevails over oral evidence. Section 91, my lord, and 92. So, my lord, Section 91, when the terms of contract or of a grant or of any other deposition property have been reduced to the form of a document, and in all cases in which any matter is required by law to be reduced to the form of a document, the sale deed is, as per Law and Registration Act, it is to be Transfer of Property Act, it is to be reduced in writing, Section 91. Well, I got it. When the terms of a contract or a grant of or any other disposition of property have been reduced to the term of document, and in all cases in which any matter is required by law to be reduced to the form of a document, no evidence shall be given in form of the terms of such contracts, grant, or other disposition of property or such matter, except the document itself or secondary evidence of its contents in cases in which secondary evidence is admissible under the provisions of the herein contained. In this case, my lord, the sale deed, my lord, which the plaintiff's predecessor, my lord Madhusudan Pal, out of 14 kata, 3 tax and 10 gonda, he had sold 3 kata of land to Shankar Ranjan PW3, and Shankar Ranjan in the appellate stage, my lord, after getting the permission by Exhibit 5, filing a petition, the Honorable Appellate Court allowed his evidence, and by the original, Exhibit 4 is the original sale deed he exhibited, my lord, the purchase deed of 3 kata land from the predecessor of the plaintiff, my lord, the Madhusudan Pal. There is Exhibit 4, my lord, exhibited in origin, my lord, original, and the purchaser himself, my lord, appeared before the court in the witness box, my lord, and he submitted by adducing the original sale deed that he had purchased the 3 kata land from the Madhusudan Pal, the predecessor of the plaintiff's, my lord. And in the cross-examination, this question is not put, my lord, that whether this Exhibit 4 he was purchased or not. This is important, my lord. The Exhibit 4 was exhibited in origin, and that question is not put to him, my lord, regarding his purchase of 3 kata, regarding the Exhibit 4, my lord. That is unrebutted, my lord. So, my lord, there is no doubt that the proof of Exhibit 4 original, though the plaintiff exhibited in the certified copy or Xerox copy the same deed, my lord, Exhibit 3, and the PW3 exhibit is in original as Exhibit 4, my lord. Exhibit 5 is the petition by which the learned appellate court allowed him to adduce the additional evidence in appellate stage, my lord. So this is proved, my lord. This is proved by documentary evidence, and my two citations, my lord, I have placed, my lord, in Saityendranath Tripura High Court's case, my lord. Saityendranath versus Kadambini Devnath, my lord, paragraph number 9. Paragraph number 9, may I read, my lord? Non-appreciation of evidence in no doubt a substantial question of law in second appeal. In the second appeal, the appellant has to show that there was a total non-appreciation of evidence on record if in a suit both oral and documentary evidence is adduced, and the suit is decided taking into account the documentary evidence. There is nothing wrong in the decision taken by trial court or by an appellate court. Documentary and oral evidence are both forms of evidence described under the Evidence Act. Documentary evidence always prevails over oral evidence. If an issue is proved by documentary evidence, in that case, court of law may not elaborately discuss the oral evidence. Now, paragraph number 10. In the present suit, the plaintiff proved the order of allotment in the name of her predecessor, Radharani Nath, which marked as Exhibit 1, and she also proved the order of the collector accorded permission of Radharani Nath to sell the suit land, which is proved and marked as Exhibit 2. Plaintiff also proved Khotian prepared in her name, which is marked as Exhibit 4, and finally published Khotian, which marked as 5. Allotment order was issued so and so. There is no scrap of paper to show that the defendant was in possession of the suit land on date of allotment so and so. Defendant contended that he has been possessing the land from 1/1/77. Had it been so, this name would have been reflected in the Khotian as an occupier of the suit land. The trial court had and the appellate court both considered the material document, the allotment order so and so, Tripura land revenue reform so and so. There is a presumption of correctness of entries made in the Khotian until contrary is proved. The record of right prepared finally published should be presumed to be correct. A Khotian is a prima facie proof of possession so and so. The plaintiff alleged that she has been dispossessed from the suit land and so and so. The defendant has no doubt adduced oral evidence to show that defendant is in possession since long. But since there is a documentary evidence, the trial court as well as the appellate court relied on the documentary evidence and find nothing wrong in the taking such decision by the courts. In that case, though there is a oral evidence, my lord, regarding possession, but the courts below, depending on the documentary evidence, my lord, decreed the suit of the plaintiffs, my lord. In the second case, my lord, of the Allahabad High Court, my lord, regarding this documentary evidence prevails over oral evidence, my lord. Paragraph number 20, Allahabad High Court, my lord, Ram Horok and others. Paragraph number 20, my 20. 20, my lord, may I read one paragraph, my lord? When a documentary evidence was present, it prevails over oral evidence. If a person is challenging anything contained in the documentary, then heavy burden lie upon such person to prove such fact by adducing best evidence, which has not been done in the case and in plaintiff. Mere assertion of the oral testimony that plaintiff 2 and 3 were not present and the document did not contain their thumb impression is not sufficient when defendants cite otherwise and better evidence could have been adduced in that case in hand, which has not been done by the party whose responsibility it was placed best evidence. In this case, my lord, the exhibit 4, the selling of 3 kata land to the PW3 is proved, my lord. Is proved by the purchaser himself by appearing before the court and appearing before the witness box. What happened, my lord? The case of the plaintiffs is that, my lord, the predecessor of the plaintiffs is not, he has no title to transfer 14 kata 3 sotak and 10 gonda of land. He has the title of only 11 kata 3 sotak and 10 gonda of land. So the learned appellate court held that since the vendor has no title, the defendant vendor has no title over the land he has transferred 14 kata 3 sotak and 10 gonda. So this deed is not, my lord, valid in the eye of law because he has transferred more than the he has the title, my lord, and it is not my lord, he is not entitled to sell, and thus such sale is not, my lord, valid in the eye of law, my. And my lord, regarding their purchase, my lord, the learned appellate court specifically held that the 14 kata 3 sotak and 10 gonda land purchased by them, that is not proved by them. Not proved by them, it is their case to prove their sale deed, my lord, that they are the owner of this 14 kata 3 sotak 10 gonda land by adducing evidence, my lord. They cannot establish their case, my lord, on the weakness of the plaintiff evidence, my lord. They have to establish their case. They have to establish the title of their vendor, my lord. Their vendor has the title of the 14 kata 3 sotak of 10 gonda land. We have proved, the plaintiff have proved that the vendor has no title over 14 kata 3 sotak and 10 gonda of land. So, my lord, regarding my lord, this presumption, my lord, I will place 3 judgments, my lord, of this. So, my lord, Vidyadhar, the Honorable Apex Court, in paragraph number 16 held, my lord, in Vidyadhar case, my lord.
Yes.
My lord, paragraph number 16, may I read, my lord? Where a party to the suit does not appear into the witness box and state his own case on oath and does not offer himself to be cross-examined by the other side, a presumption would arise that the case set up by him is not correct, as has been held in a series of decisions passed by various high courts and the Privy Council beginning from the decision of so and so. This was followed by Lahore High Court in the year 1930 and the Bombay High Court in so and so. The Madhya Pradesh High Court so and so also followed the Privy Council decision in Sardar so and so. The Allahabad High Court in so and so held that if a party abstains from entering the witness box, it would give rise to an inference adverse against him. Similarly, in a division bench of so and so, drew a presumption under section 114 of the Evidence Act against a party who did not enter into witness box. So, my lord, in Judmati case, my lord, of our Honorable High Court, Judmati case, paragraph number 18, my lord.
Yes.
Paragraph number 18, my lord. On behalf of the defendant, we have the statements of so and so alone apart from certain documents placed on records in support of their defense. In paragraph number so and so, written statement of defendants had candidly admitted that they had no knowledge how to and when so and so entered upon the suit property. In the examination in chief, though Punaram Singh happened to affirm that property belonged to his father and that they had inherited the property from him, in his cross-examination, he was frank in admitting that he could not detail how his father had got the land and that the facts was also not known his mother. He could not deny that the patta was land first stood in the name of Anisu Rasul so and that now it stands in the name of plaintiff. Defendant number 1, Jurmati, it has to be emphasized, avoided the witness box. The circumstances cannot be lightly ignored. It is for the reason that, according to the plaintiff unequivocal case, she had let out the property to Jurmati and not to husband Sangaram. Therefore, it was proper for the Jurmati to enter into the witness box and take the court into confidence about the true state of the. It will be noticed that according to the allegations of defendants, the premise in dispute was the first instance, Jurmati along with her husband, and that defendant number 2 and 3 were subsequently born to the couple during so and so. In the question, those pleading, it was Jurmati and not her son Purnam Singh who knew the facts best. It is therefore legitimate this presumption that Jurmati has deliberately withheld itself from the witness box to avoid some vexing questions in cross-examination. Next, my lord, Karnataka High Court case.
Paragraph number?
Paragraph number, my lord, 45, my lord.
Yes.
In respect of exhibit D8, which was allegedly executed by defendant number 1, it was found that she had neither denied its execution in a written statement nor stepped into the witness box to dispute it. Consequently, under section 114G of the Indian Evidence Act, an adverse inference was justifiably drawn against her. Principle laid down in the case of so and so was applicable, wherein it was held if a party fails to rebut an alleged within their knowledge, the court is entitled to presume the correctness of the opposite party's version in the present case by filing to dispute exhibit D8. Defendant 1 allowed the document to acquire evidentiary strength. The trial court observed that exhibit D8 and D7 were execution on the same day before the same notary, and non-denial on GPA defendant 1 significantly weakened the appellant's challenge to the other. So, my lord, my humble submission is that, my lord, in this case, my lord, by failing to come to the witness box, my lord, by the defendants, my lord, they failed to prove their case, my lord, regarding their purchase of the suit schedule land, my lord. The suit schedule land, the plaintiff's claim is 11 kata, 3 sotak and 10 gonda, my lord, which their predecessor, after selling 3 kata, and that is admitted, my lord, the purchase of the predecessor of the plaintiffs, the initial purchase of 10 kata of land and subsequent purchase of 1 kata of land, 11 kata, 3 sotak, 10 gonda land is admitted, my lord. It is admitted by the defendant. The defendant need not prove this facts, my lord, that their purchase of the 11 kata, the purchase of suit land is admitted by the defendants, my lord. By the predecessor of the plaintiffs from the predecessor of the defendant. It is admitted, my lord, 11 kata, 3 sotak and 10 gonda land. The dispute is that, my lord, their dispute is that the sale of 3 kata land to PW3, they are disputing, my lord. They are disputing the 3 kata land to the PW3. And that is their case that the predecessor of the plaintiff had the title of total 14 kata, 3 sotak of 10 gonda land. And this is the issue, my lord. Their dispute is that their vendor has the title, and our case is that, my lord, that their vendor has no title of 14 kata, 3 sotak, 10 gonda land. And we have proved our case that the vendor, their vendor has sold to the PW3, and PW3 by exhibiting the original sale deed before the Honorable Court as exhibit number 4, my lord. It is established that he has purchased the land of 3 kata, land from the purchaser. So it is proved before the court, learned court, appellate court below, that the vendor has no title. The defendant's vendor has no title over 14 kata, 3 sotak, 10 gonda land. And they failed to prove their case by entering before the witness box that their vendor has the title of 14 kata, 3 sotak, 10 gonda land, and the Honorable Appellate Court has rightly, my lord, decided the issue that this deed, exhibit number 6, is, my lord, not a valid document, and it is liable to be declared null and void, my lord. And the Honorable Court, my lord, rightly declared this deed is a null and void document, my lord. And by this document, the defendants acquired no right, title, interest, or possession, my lord. And this is my humble submission, my lord, before this Honorable Court.
Lordship?
Yes, any reply?
Yes, my lord. Regarding my learned friend's submission, my lord, I would like to point out in my, what I have stated in my written statement, my lord. Some statements are there vital, my lord.
That's all right, but you have not entered into the witness box to substantiate the facts stated in the written statement.
No, my lord, in that case, my lord, I'm, again, my lord, I'm coming to appellate observation, my lord. That part has to be confirmed from the record, my lord. Appellate court has stated, my lord, that plaintiff has also exhibited the original sale deed, my lord, executed by Madhusudan Pal on 12/5/87 in favor of Shankar Ranjan Das, exhibit 3, my lord. Court has recorded that original sale deed was exhibited, my lord. Did executed, my lord. So, my lord, but in the deposition of PW1, my lord, what PW1 has said, my lord? PW1 has said, my lord, আমি শঙ্কর রঞ্জন দাসের 12/5/87 ইংরেজি তারিখের দলিলের জেরক্স কপি দাখিল করিয়াছি। Xerox copy, that is exhibit 3 is Xerox copy according to deposition of PW1, my lord. এর Xerox copy exhibit 4 mark করা আছে। Again, my lord, exhibit 3 কোনো certified copy আমি বাহির করি নাই। So certified copy of exhibit 3 has not been obtained by her, my lord. And exhibit 4 is the, she has submitted that sell deed to Shankar Ranjan Das, Xerox copy has been submitted, that not even certified copy also, my lord. So, but court has recorded, appellate court has recorded that plaintiff has also exhibited original sale deed executed by Madhusudan Pal in favor of Shankar Ranjan Das as exhibit 3, my lord. So how it is proved, my lord? If Xerox copy is submitted, my lord, whether sufficient evidence has been given to establish it is it is proved, my lord, that this is correct and true copy, my lord. Simply placing Xerox copy of a deed, my lord, would not suffice, my lord.
Appellate court has held that original document being exhibit.
Appellate court.
Appellate court, my lord.
Original
In paragraph 8, my lord,
Original copy of exhibit
exhibited the original sale deed exhibited by Madhusudan Pal on 12/5/87 in favor of Shankar Ranjan Das as exhibit 3. And exhibit 3 is duly proved by Shankar Ranjan Das himself. It is written there, my lord. So it is
But the original date was not produced.
No, for evidence.
my lord, from evidence of PW1, it said that she has produced Xerox copy, my lord. PW1 is saying that she produced Xerox copy. No, my lord, one last submission, my lord. That is, my lord, regarding my learned friend's submission that the 3 kathas was sold, my lord. So original vendor was not having 14 kathas, my lord. In this regard, my lord, I have submitted another citation, AIR 2012 Gujarat 71, my lord. I have already given to lordship, my lord. It says, my lord, there is a principle, my lord. A party cannot be allowed to take any benefit of his own wrong, my lord. So in that judgment, my lord, it is that person representing another person and selling him his land cannot challenge such sale deed executed by him to be void, as it would amount to taking benefit of his own fraudulent act in executing sale deed.
Okay.
If they sold us lesser amount of land by misrepresenting, by not disclosing that 3 kathas were sold to another person, my lord, and they sell us to enter 14 kathas of land, my lord, they cannot be taken, allowed to take advantage of that, my lord.
Okay.
Okay.
Heard Mr. I.S. Laskar, learned counsel for the appellant. So M. Kadir, learned counsel for the respondent. Argument concluded, judgment declared.
अरे साहब और लश्कर साहब एक मिनट रुको ना तुम
Item number 12, my lord, when the matter was called up, my lord, I could not turn up, my lord. It's an admission matter, my lord. Can we have it on some-
Item number
12? Can we have it on the next week, my lord, any date, my lord, if not possible today, my lord?
after 1 week yes date दिया
after 1 week.
mention for
Date,
then in the month of September August, July fixed to tell you
okay, let it be on after 1 week. My lord, my presence may, if possible, my lord. Oblige me.
item 17
My lord, here I am paying for a small accommodation, my lord, short accommodation. May I pay on 5th of August, my lord?
5th of August.
August last
Any objection?
No. On 5th, my lord.
As agreed by learned advocates of both the parties, this is the list the matter on
On 26th August.
My lord, on fifth, my lord, I have some urgencies there.
Sort
Fifth,
19 of.
my lord, can it be in 31st of July, my lord, then?
No, this
Then
this
it
one
will
not
be like-
possible.
My friend is also agree on fifth, my lord, it's for our convenience.
On 14th August. 14th
Well,
August. Evening item 6.
Lordship.
Yes.
May I please, Lordship. Lordship, so far, the matter is though listed for referring to the mediation center, Lordship. But you know, this may be disposed of by a covered case. My other side is there. A covered case is there. Because what happened in this case, Your Lordship? The claim case, MSCT claim case was dismissed on the very date of admission on the ground that limitation is applicable. It is filed after 6 months, so it was dismissed. The particular provision, section 53 of the amended act, was not made applicable by that time. That was made applicable in 2022. My case was dismissed in 2019 for the limit. That you Lordship kindly see. This is the amended provision. It is here, Your Lordship. 166.3. It made applicable. Your Lordship, may I read, Your Lordship?
Yes.
Your Lordship, so far 166 is concerned. It was amended in 2022. The amendment was though made was in 2019. It was made applicable from 1/4/2022, Lordship. MSc MB Act.
Hmm.
166 subsection 3.
Yes.
This subsection 3 says no application for compensation shall be entertained unless it is made within 6 months of the occurrence of the accident. This provision was made applicable, Your Lordship, say footnote 2.
Yes.
It was made
effect from
applicable from 1/4/22.
1st of April 2022.
Yes, but my case was dismissed because amended act was passed in 2019. But this particular provision was made notified and it was made applicable from 22. My case was dismissed in 2019 on the basis of this provision. And this is a covered case by this court that this is not applicable. It was not applicable at that time. Same case, similar case, it is our court judgment is there. I have underlined the relevant provision and relevant para, Your Lordship. Para 7, 8, and 11. And Your Lordship, this is
Yes,
gazette.
any objection?
No, it can be remanded back for fresh adjudication.
Because Your Lordship, last 5 years, 6 years, nothing has happened in this case. The person died in 2019. So in terms of para, it may be remanded back for try the case as per law. That will be the appropriate one.
Pardon, Mr. B.K. Zain, learned counsel for the appellant. And Mr. Dr. for respondent.
Number 3.
Your name has not been reflected in the.
As per the last order, there was a direction to reflect my name. Your Lordship may see 20.
You have filed your wakalat nama.
Yes. In the condonation I have checked, there is a wakalat nama.
Okay, check the record if his name is there.
Last what's up? Condonation.
Yes. Nunca passei.
The impugn order is updated 5/11/2019.
Yes, Lordship. Your Lordship, it is at page 11, Lordship.
Yes,
May I read it?
no, not necessary.
11.
Page 11. Court presumed that this amended provision 53 is made applicable when though it was not notified. And that notification I have given your Lordship, section 53 is not there.
This appeal under section 173 of the MB Act. The appellant has challenged the order dated 11/11/2019 passed by the learned member, Motor Accident Claim Tribunal, Barpeta, in MSC case number 147 of 2019. It is to be noted here that by the impugn order dated so the learned tribunal has dismissed the appeal on the point of limitation. Mr. Zain, learned counsel for the appellant, submits that the accident took place on
It took place, Lordship, on 6 to 19.
on 6 to 19.
And claim case was
And,
filed on 21
And
8.
thereafter, the appellant herein had preferred the claim petition before the learned tribunal on
21 8 19.
21/8/2019. 21/2019. But the learned tribunal has dismissed the same for being filed beyond the period of 6 months, as mandated by the Amendment Act of 2019. In view of the section 53, within bracket 3 of the Motor Vehicle Amendment Act 2019. Mr. Zain, learned counsel for the petitioner, also pointed out that though the MB Act was amended in the year 2019, the provision of section 166, within bracket 3, came into force with effect from 1/4/2022. And in that view of the matter, no, yes, the same was published in the official gazette. In the Gazette of India on. Here, effect, date of effect is mentioned here.
Yeah, Lordship, this notification is not regarding section 53. It is as per this provision which was applied by the court. 53 was not applicable as per this notification. 53 was not notified. Section 49 to 57 was not notified. Lordship.
2020. And in that view of the matter, the impugned order so passed by the learned trial court, dismissing the appeal papered by the no, by the tribunal, dismissing the appeal papered by the appellant is and erroneous and arbitrary, and therefore the same requires interference of this court. Mr. Zain has also referred to a decision of a court in advance of this court in the case of CRP 172 of 2019. Dated 3/3/2021. Wherein a court in advance of this court has held that notwithstanding the enactment of amending Act 2019, Section 50 to 57 thereof must be deemed to have not come into force as the central government has not notified the date of appointment for coming into force of the said provision. And thereafter, the learned, this court was pleased to set aside the impugned order dated 3/11/2019 of the said petition and remanded the matter. No, and directed the learned tribunal to restore the file, restore the MSC case number 157 of 2019 to the file, and thereafter to proceed with the said claim petition in accordance with law. And the present case also, after setting aside the impugned order dated 11/11/2019, the same may be remanded to the learned trial court, the tribunal, to proceed with the claim petition in accordance with law. Mr. S. Dotto, learned counsel for the respondent, submits that he has no objection in the event of remanding the matter back to the learned tribunal. Having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents placed on record, and also perused the impugned order dated 11/11/2019. And it appears that the learned tribunal has relied upon a gazette notification dated 28 August 2019. Then thereafter held that the said provision came into force, and being the claim petition filed beyond the period of 6 months, dismiss the claim petition being not maintainable in law. It is not in dispute that though the amended act was notified on 18th of August 2019, yet Section 53 of the said act came into force with effect from Section 53 of the said act, along with Section 166 subsection 3, came into force with effect from 1/4/2020 to 1/4/2020. And as such, dismissal of the claim petition by the learned tribunal on the ground of being filed beyond the period of limitation is erroneous, and the same were an interference of this court, and accordingly the same stands set aside and passed. The matter stands remanded to the learned tribunal to proceed with the claim petition filed by the claimant, being MSC case number 147 of 2019, in accordance with law. Since the accident took place in the year 2019, and the claim petition was filed on 19, no, when it was filed? claim
It was
petition?
filed on 21/8/19.
21/8/19. This court inclined to request the learned tribunal to expedite the matter of hearing and to dispose of the same as soon as practicable, preferably within a period of 6 months from the date of receipt of certified copy of this order. The petitioner shall obtain a certified copy of this order and place the same before the not petitioner appellate. Before the learned tribunal within a period of 1 week from today.
Okay.
Item number 18. Wait, please. The regular first appeal under section 96 of the CPC. Madam. The respondent filed a suit for specific performance of contract. The suit was partly decreed and specific performance of contract was granted in favor of the respondents. But the brief facts of the case is that, my lord, the respondent entered into an agreement on 3/11/2014 with the present appellant in respect of a plot of land measuring 1 bighah, 2 kotha, 10 lesas. At a total.
What is the agreement?
Agreement, my lord, will find as Exhibit 1.
Is it part of this memo?
Ma'am,
Of
not
this
memo of
case?
appealment, not a part of it. Records पे call from. Exhibit 1. The first agreement for sale. It is in vernacular medium. Let us go. Correct. It is filed along with PW1. C5. C5.
Okay, yes.
My lord. Borabar Sri Madhav Karki, he is the plaintiff respondent, and Likhitong Sri Subhas Brahma, he is the present appellant defendant, my lord. So course, it was fixed at a total consideration of rupees 33 lakhs, my lord, in respect of 1 bighah, 2 kotha, 10 lesas of land. If my lord comes to the next page, that is very important, my lord. Next page, second line I am reading. Prakash থাকে যে আজি 5 লাখ টকা বাইনা হিসাবে গ্রহণ করার, so 5 lakhs advance was paid out of 33 lakhs. গ্রহণ কৰাৰ পাছত বাকি থকা এই 28 লাখ টকা অহা 28/2/2014 ইংৰাজী তাৰিখৰ ভিতৰত সম্পূৰ্ণভাৱে দিয়া হ'ব. So my lord, 5 lakhs advance was paid on 3/11/2014. And the rest amount of 28 lakhs would be paid within 28 to 2014. So time was the essence of contract. And in fact, they have admitted in the pleadings also that the defendant wanted to sell the plot of land because of urgent necessity of money because of some family problems, family issues. So my lord, here it is crystal clear that the time was the essence of contract, and within 28 to 2014, the total sale consideration amount of rupees 33 lakhs would be paid to the defendant by the plaintiff. Thereafter, my lord, another agreement for sale was entered into, that is the next exhibit, Exhibit 2, on 27/1/2015, in between the same parties. And it is their case that they have paid another amount of rupees 10 lakhs as advance. So total they had paid 15 lakhs as on 27/1/2015. In this document, my lord, that was executed on 27/1/2015. I'll just read out, my lord, clause number 4 and clause number 5. That is at internal page 3. That is very pivotal, my lord. Clause 4, that the first party, by executing this mutual agreement after proper demarcation. My lord has got it.
Serial number?
Serial number 4, internal page 3. That the first party, by executing this mutual agreement after proper demarcation and in presence of the witnesses, has handed over the physical possession of the scheduled land to the second party. So according to this document, possession was also handed over to the plaintiff by the defendant. Para 5, clause 5, that the first party empowered the second party to start Pakka RCC construction as per requirement and choice of second party over the schedule mentioned plot of land before registration of the sale deed. And he was given permission to undertake construction also. These 2 points are why it is necessary, my lord, because this is not a registered document. This is a notarized document, and if delivery of possession is given as per agreement for sale, my lord, then it has to be compulsorily registrable, my lord. There are a number of judgments. I'll be coming to that later on, my lord. It is hit by section 35. If possession is given, if there is a recital about possession being delivered by the vendor to the vendee in lieu of an agreement for sale, then that document has to be compulsorily registrable because stamp duty is leviable, my lord. And if stamp duty is not paid and if it is not registered, my lord, then that document is not inadmissible in evidence, and it can be impounded by the court, my lord. Thereafter, my lord, they have produced Exhibit 3. That is a money receipt. Exhibit 3 is a money receipt. Now, this document has not at all been believed by the learned trial court, saying that there is no mention of the plot of land or any recital with that effect, that the payment was made in respect of the sale of a plot of land. So according to this document, my lord, the defendant has paid a total sum of money rupees 20 lakhs. How he has paid, my lord, about this document, there is no mention in the pleadings also, my lord. Straight away, they have filed this document in the evidence in chief. There is absolutely no mention in the pleading, in the plaint.
This document.
This document. And regarding the payment of the third installment, that is 4 lakhs. No mention in the pleadings, my lord. So far, my lord, it is crystal clear that there were 2 agreements for sale according to them, and they have paid as per the agreement for sale an advance amount of rupees 15 lakhs. Now, they have pleaded in their plaint that another amount of rupees 1 lakh and another amount of rupees 1.5 lakhs were paid to the pro forma defendant, who accepted the money on behalf of the defendant. Our case was that, my lord, we do not know pro forma defendant who he was, my lord. He is a person, my lord, known to the plaintiff. And in fact, in the cross-examination of PW2, who is the son of the pro forma defendant, he has admitted that pro forma defendant number 2 was imprisoned for life, and he died in the jail, my lord. So all those recitals were taken care of, and the court came to the conclusion that, my lord, as per them, they have paid a total amount of rupees 23 lakhs 50,000 as total advance sale consideration. But the court below has held that they have failed to show that they have paid 23 lakhs 50,000 as advance amount. And the court has taken note that as per the agreement for sale, only 15 lakhs have been paid. So the advance amount was taken as 15 lakhs. Now, in all the in all the recitals, all the pleadings, my lord, they have said that they are ready and willing to pay only an amount of rupees 9,50,000. That has been reiterated in number of paragraphs, my lord. At paragraph number 8 also it is reiterated that 9.5 lakhs they are ready and willing to pay. But if they have paid an amount of rupees 15 lakhs, and if I consider that they are ready and willing to pay 9.5 lakhs, my lord, then the total sale consideration comes to around 24 lakh 50,000, my lord, instead of the total sale consideration that is 33 lakhs. So where is the readiness and the willingness, my lord? If the court has come to a conclusion that 15 lakhs was paid as advance amount, then the remaining balance amount, that is 18 lakhs, then they have to be ready and willing to pay rupees 18 lakhs throughout the course of the time, my lord. And now they have stated themselves that they are ready and willing to pay only 9.5 lakhs. Then where is the readiness and willingness to pay the total sale consideration amount? Court below has not considered this part of the matter. Then thereafter, my lord, interestingly, another part is that the land belongs to the tribal belt area. And our case was that, my lord, since they do not belong to the tribal belt, or they are not tribal people, my lord, so I cannot sell the land to them. I'll be coming to the judgment part. The learned court below has held that they belong to Gorkha community, my lord. But nowhere in the pleadings, my lord will find, as well as the plain in the evidence in chief, they've stated that they belong to the Gorkha community. Only in the cross-examination, they have merely stated that they belong to Gorkha community, but no documents have been furnished, my lord. Simply, they have stated in the plain, that is at page number 11, my lord will find.
Page number?
Page number 11.
The memo of appeal?
Memo of appeal. First page of the plaint. Plaintiff, Sri Madhav Karki, aged 50 years, my lord has got it. Resident, son of so-and-so, resident of so-and-so, Safargut district, Kokrajhar, BTAD, Assam, religion Hindu, caste OBC. So only this much has been pleaded, caste OBC. Now whether that caste OBC belongs to Gorkha community or some other tribal people, my lord, that is not at all, my lord, stated in the plaint, or neither in the evidence in chief, my lord. Now the court has on ipso facto, my lord, suo motu has considered that no, he belongs to Gorkha community, and that has not been denied by the defendant. Since he has not pleaded that he belongs to Gorkha community, how can I deny? This part is also very important, and that goes to the root of the matter, because the land belongs to tribal belt, and I cannot sell any portion of land to any person who does not belong to the tribal belt community. Section 10 of the Assam Land and Revenue Regulation. Chapter 10. Chapter. My lord will not find a single pleading, my lord, that he belongs to Gorkha community. Not a single document also. That is perversity, my lord. Now the first agreement, my lord, has gone through, that was entered into in the month of November 2014, where it was specifically stated that the balance consideration amount of rupees 28 lakhs would be paid on 28 to 2015, my lord. Thereafter, another agreement was entered into in the month of January. Now, from the month of January 2015 and November 2014, they have not taken any steps to pay the remaining amount, my lord. And straight away, my lord, if
No,
it comes to
within the stipulated period in the first agreement, they have not paid the amount.
no, not paid the amount.
And
Then
why
hereafter-
the subsequent agreement was entered into?
Thereafter also, my lord, they have not made the payment. Till December 2017, they have not approached us also. That it is their own pleading, my lord, at paragraph number 9. That my lord will find at page number 14. They have not approached us, they have not paid the amount, my lord. Paragraph number 9, page 14, 14. That it is
Paragraph number 9.
9, my lord. Page 14.
Yes.
14. My lord has got it. That it is now submitted that after arranging the said remaining balance portion of consideration of sale money, rupees 9.50 lakhs, only with a view to purchase the suit land from defendants as per terms and conditions of the said deed of mutual agreement. It is the plaintiff along with his family members and friends who met, approached and requested the defendants on and around the last week of the month of December 2017 to sell the suit land in favor of the plaintiff by executing necessary formal registered sale deed in respect of selling of the suit land in favor of the plaintiff upon and after taking the remaining total balance consideration amount of sale money of rupees 9.5 lakhs. So my lord, till December 2017, they have not taken any steps. And the agreement for sale being an urgent necessity in respect of the defendant, my lord, and time was the essence of the contract, they did you burn an incumbent, my lord, to pay the balance amount within a reason, at least within a reasonable period of time. Now, where from this 9.5 lakhs have come, my lord? If my lord comes to the top the same page, my lord, paragraph number 8, the first paragraph. Same page, my lord, same page. Para 8.
Yes.
That it is further relevant to mention here that a pro forma defendant on behalf of the defendant has received 1 lakhs on 12/4/16 from the plaintiff, and again on 6/8/2016, the said pro forma defendant has also again received rupees 1.5 lakhs from the plaintiff and has duly acknowledged that the defendant has till date received rupees 23,50,000. Even assuming that, my lord, the pro forma defendant has accepted money on my behalf, 1 lakh and 1.5 lakhs, plus that 15 lakhs advance amount. So it comes to, my lord, 17.5 lakhs. So where from this 23.5 lakhs has come into the picture, my lord? Absolutely no explanation. They've straight away come to the conclusion that 23.5 lakhs were paid. First, 5 lakhs were paid, my lord. That was the agreement executed in the month of November. Another amount of 10 lakhs was paid in the month of January 2015, my lord. Then they have stated that they have paid 1 lakh to the pro forma defendant on 12/4/16 and another amount of 1.5 lakhs to the pro forma defendant on 6/8/2016. So even admitting their pleading, my lord, that I have received through the pro forma defendant, then the total advance amount comes to 17.5 lakhs, my lord, and not 23.5 lakhs. So it is from their own pleadings, my lord. Their own pleadings are contradictory to each other. They are not even sure as to what amount of money was paid as advance amount to the defendant. And in the exhibit 3 that my lord has gone through the money receipt, they have stated that I have received 20 lakhs. So there are so many My lord, nothing is, my lord, clear from the picture, my lord. Once they have said 23 lakhs, one they have said 20 lakhs, another picture they are saying 17 lakhs, my lord. So all the documents and the pleadings, they are not corroborating each other, my lord. So thereafter, they have stated that, my lord, they have tried a number of times to get the sale deed executed, but the defendant on this and that plea has not executed the document, my lord. So finding no other alternative, they have filed the present suit. On receipt, my lord, I filed my written statement rebutting and refuting the allegations, my lord. And thereafter, evidence was laid down and the learned trial court held that the plaintiff has paid an advance amount of rupees 15 lakhs. And as such, they are liable to get the sale deed executed from the defendants. The judgment, if my lord comes through, that is at page number 28. Issue number 3 and 4 is important, my lord. Issues, my lord, will find at page number 41. Yes. Main issues are 3 and 4, my lord, that is at page number 44. Para 24, the defendant has admitted the sale agreement dated 3/11/2014 Exhibit 1, but did not whisper a single word regarding date of mutual agreement dated 27/1/2015 and simply denied it. The defendant was in dire need of money and he executed the agreement to meet up his financial urgency. The total consideration of money was fixed at rupees 33 lakhs and the plaintiff has paid an advance of rupees 5 lakhs in cash to the defendants towards sale of the suit land to the plaintiff as mentioned in Exhibit 1 and promised to register the sale deed in favor of the plaintiff after receiving the balance amount of rupees 28 lakhs within a period of 3 months, that is 28 to 2014. On 27/1/2015, again, both the parties have entered into one deed of mutual agreement in continuation to agreement dated 3/11/14 and a sum of rupees 10 lakh only in cash was paid by the plaintiff to the defendant on the very day of execution of the said deed and received acknowledgement for the same, and thus a total advance payment of rupees 15 lakh is paid by the plaintiff to the defendant. It was agreed by both the parties that the rest amount of rupees 18 lakhs will be paid at the time of registration of the sale deed. In both the Exhibit 1 and 2, the defendant has put his signatures in presence of witnesses and entered into an agreement for selling of the scheduled land in favor of the plaintiff. The defendant has not raised any question regarding his signature on Exhibit 2. The PW1 further stated that the pro forma defendant has received an amount of rupees 1 lakh and 1.5 lakhs on 12/4/16 and 6/8/16 respectively from the plaintiff in respect of sale of the suit land on behalf of the defendant and duly acknowledged the same. But the defendant has straightly denied knowing of pro forma defendant and having any connection with him. He also denied sending of any person to receive money from the plaintiff on his behalf. As per evidence of the PWs, the pro forma defendant has expired and his son has deposed as PW2 in the suit. The PW2 has deposed that he used to accompany his father whenever he goes due to his poor health issues. But in his cross-examination, he clearly stated that he doesn't know about receipt of rupees 1 lakh on 12/4/16 and rupees 1.5 lakhs on 6/8/16 by his deceased father from the plaintiff on behalf of the defendant. The PW2 has not corroborated the facts regarding the acceptance of money by his father from the plaintiff on behalf of the defendant. The plaintiff has failed to prove that a pro forma defendant has received money from him on behalf of the defendant and therefore cannot be counted in total consideration money received by the defendant. It is claimed by the plaintiff that the defendant has duly received 23.5 lakhs in total from the plaintiff in respect of the sale of the suit land in favor of the plaintiff, but on computation of the amount mentioned above, it resulted in rupees 17.5 lakhs in total as paid to the defendant, out of which the plaintiff has failed to prove the receipt of rupees 2.5 lakhs by the pro forma defendant on behalf of the defendant. The plaintiff has not mentioned any other amount in addition to the above amount in the suit. The Exhibit 3 is the total money receipt of rupees 20 lakhs having signature of the defendant, but the said exhibit is not admissible as evidence as it failed to prove that the said amount was received by the defendant from the plaintiff in connection with the subject matter of the suit. From the above discussions, it is found that the plaintiff has paid rupees 15 lakhs out of the total sale consideration money of rupees 33 lakhs to the defendants towards selling of the suit land in favor of the plaintiff. Thus, the issue is decided accordingly. Issue number 4, whether the plaintiff is ready and willing to perform his part of the contract for sale of the suit land. The defendant took the plea that the plaintiff did not come forward to execute the registered sale deed on time by paying the balance sales price to the defendant. As such, the suit is barred by Section 16C of the specific performance of contract and liable to be dismissed. A plaintiff seeking to enforce a contract must show that he has performed or been ready and willing to perform all the terms which ought to have been performed by him, and also willing to perform all future obligations under the contract. The word ready and willing imply that the plaintiff was prepared to carry out those parts of the contract to their logical end, so far as they depend upon his performance. The terms of a contract performable by the plaintiff may be of two kinds: those that have to be performed before the other side can be called upon to fulfill his promise, and others that may be subsequently performed. The continuous readiness and willingness on the part of the plaintiff is condition precedent to grant the relief of specific performance. In the instance suit, the plaintiff PW1 has stated that he is ready and willing to perform his part of the contract by paying the balance amount of consideration money to the defendant. The plaintiff has arranged the remaining balance amount of rupees money with a view to purchase the scheduled land from the defendant and approach the defendant to execute necessary formalities for the registered sale deed after taking the balance consideration money. But all of the times, the defendant sought time from the plaintiff by tendering due assurances and promises to execute his part of the contract, and ultimately denied to execute the suit land in favor of the plaintiff, and as such, finding no other alternative, the plaintiff was compelled to file this present suit before this court. Para 31, as per the terms and conditions of the deed of mutual agreement dated 27/1/15, it was mutually agreed that the plaintiff will pay the rest consideration amount of rupees 18 lakhs at the time of registration of the sale deed. The other terms and conditions are required to be performed by the defendant. As per evidence of the PW1, the plaintiff had requested the defendant on several occasions, that is on 11/6/19, 27/19, 11/8/19, 15/9/19, and lastly on 2/10/19, to take the balance amount of consideration and to execute the sale deed in favor of the plaintiff. But the defendant is not willing to take the money and perform his part of the contract dated 27/1/15. The PW1 has deposed that he was accompanied by the PW3 and others on 2/10/19 when he met, approached, and requested the defendant to execute the registered sale deed upon taking the remaining balance consideration money, which the PW has corroborated. The plaintiff has already paid rupees 15 lakhs as advance payment in respect of the suit land and willing to execute his part of the promise as soon as the defendant fulfills his promise to register the sale deed in his favor. The defendant has failed to prove any contrary evidence against the plaintiff. Therefore, this issue is decided in favor of the plaintiff. Now, my lord, I have already stated, my lord, that he is ready and willing to pay only 9.5 lakhs as the balance sales consideration amount. Whereas the balance sales consideration amount, my lord, taking into consideration that 15 lakhs rupees has only been paid. So it was 18 lakhs and not 9.5 lakhs. So if a person is ready and willing to pay only 9.5 lakhs out of the balance consideration amount of rupees 18 lakhs, my lord, then where is the question of his readiness and willingness? The learned court itself has held that he has only paid rupees 15 lakhs and not 23.5 lakhs. So being that situated thus, my lord, then there is absolutely no question that the plaintiff was ready and willing to pay the total remaining balance amount of rupees 18 lakhs. In fact, he has himself admitted that 9.5 lakhs was paid. Issue number 5, whether the defendant neglected to execute the sale deed with respect to the suit land with the plaintiff after taking the advance consideration from the same. From the pleading of either parties, it is evident that the defendant was reluctant to execute the sale deed after taking the advance consideration money with an excuse that the plaintiff has not paid the balance consideration amount within the stipulated time period, that is 3 months as agreed as per the contract dated 3/11/14. Time in contracts for sale of immovable property is not of essence of contract unless the nature of property and surrounding circumstances makes it so. It is already decided that the plaintiff was ready and willing to perform his part of the contract, but it is the defendant who delayed the whole process by not accepting the balance amount of consideration and by not taking any steps towards registration of the sale deed as agreed upon. Now, my lord, balance consideration was paid as per Exhibit 1, my lord, 28/2/2015. And it is your own case that they have come and approached the defendant in the month of December 2017. That is almost after 3 years, my lord. Perhaps, my lord.
So we'll resume after the break.
Item number 18 to continue.
Wait, please, man. So, man, we're dealing with issue number 5 at page number 50, man.
Page number?
50, 50.
Yes.
Whether the defendant had neglected to execute the sale deed with respect to the suit length with the plaintiff after taking the advance consideration for the same. From the pleadings of either parties, it is evident that the defendant was reluctant to execute the sale deed after taking the advance consideration money.
You are reading page number?
50, my lord, 50, para 32.
Para 30?
32.
Yes.
From the pleadings of either parties, it is evident that the defendant was reluctant to execute the sale deed after taking the advance consideration money with an excuse that the plaintiff has not paid the balance consideration amount within the stipulated time period, that is within 3 months, as agreed as part of the contract dated 3/11/2024. Time in contracts for sale of immovable property is not of essence of the contract unless the nature of the property and surrounding circumstances make it so. It is already decided that the plaintiff was ready and willing to perform his part of the contract, but it is the defendant who delayed the whole process by not accepting the balance consideration amount and not by taking any steps towards registration of the sale deed as agreed upon. But now here I'll pause for a moment, madam. Here the court has cast the duty of sale permission upon the defendant. Whereas if my lord goes to the evidence part, the pleading is completely silent as to who will take the permission, sale permission. Neither in their agreement it is written, my lord, who will take the sale permission. But if my lord goes through the cross-examination part and the evidence in chief, it is specifically stated by the plaintiff themselves that they are to take the sale permission. Now, without there being a sale permission or NOC from competent authority, can the defendant execute the sale deed, my lord? That is the main question. Here the court has not gone into that aspect of the matter. If my lord takes up the cross-examination of PW1, I'll just read out 3-4 lines, madam. Page 6, internal page 6, madam.
Of this judgment?
My lord, page 6, internal page 6 of the cross-examination of PW1. Cross-examination.
Of this judgment?
Not from this judgment, cross-examination, schedule C file. File C, madam. Cross-examination of Madhav Karki, my lord, that was taken on 30th of July, 2022.
Cross-examination of PW?
PW1.
PW1.
Madhav Karki, the plaintiff.
Internal page number?
6.
Yes.
My lord. I'm reading for 3-4 lines. 3 lines. সত্য নহয় যে মোৰ সাক্ষীৰ 7 নম্বৰ দফাত কথা মিছা মাটি কিনা বেচাৰ বাবে পাৰমিশন এপ্লাই কৰিছিলো যদিও আজিলৈ ওলোৱা নাই so he has applied পাৰমিশন এপ্লাই কৰা নথি আদালতত জমা দিয়া নাই সত্য নহয় যে মই পাৰমিশন এপ্লাই কৰা নাই so he has admitted that he has applied for the permission although there is no documents to show that he has applied for the permission if there is no sale permission my lord and if there is no NOC from competent authority, how can the defendant execute the sale deed, my lord, in respect of the plot of land?
No, but it has not been specifically stated in the agreement. Who will,
My lord, that is there. But they have taken the burden upon themselves, my lord. Now,
Yeah. It's. No, I'm saying it is an agreement.
now again, if my lord comes to PW2, that is one of the son of one of the witnesses, my lord, at page para 5, PW2 examination in chief.
Yes.
Para 5, that I know that it was mutually agreed by both the plaintiff and defendant that the plaintiff will obtain the required sale permission from competent authority and in my presence, the defendant has put a signature. Now, my lord, he has also admitted similarly, PW3 has also stated the same thing, my lord. It was mutually agreed upon both the parties that the plaintiff will obtain the necessary sale permission from the competent authority. Now, if there is no sale permission, no NOC, my lord, how can I execute the sale deed, my lord? This clearly goes to show that, my lord, the plaintiff has failed to perform his part of the contract, and plus he has not produced any document to show that he was ready and willing to execute the final sale deed, my lord. There was no bank statement to show that he was ready and there was willingness on his part, and he has the financial capacity to pay the remaining balance consideration sale amount of rupees 18 lakhs, my lord. In this regard, my lord, I'll be placing a judgment of our Honorable Guwahati High Court. 2014 6 GLR, page number 632. Para 10 to 12. Para 10 I'll be taking first. Substantial question of law number 1. Whether suit of the plaintiff for specific performance of contract was devoid of case of action being premature. To decide this question, it is necessary to have a look at the plaint. The plaintiff pleaded in para 5 of the plaint that he approached the defendant with rupees 10,000, which is the balance amount, and requested him to accept the same and execute the sale deed in respect of the Schedule B land. But the defendant delayed the matter with some baseless plea. It is further pleaded in the same paragraph that a notice to advocate was issued to the defendant by registered post, but the defendant was delaying the matter unnecessarily without any reasonable justification. A suit for specific performance of contract can be said to have been established if the plaintiff succeeds to establish some essential steps. First of all, the plaintiff is to prove that there was a valid agreement of sale entered into by the defendant in his favor, containing terms of agreement. Once the first step is performed, the plaintiff is required to further show in the second step that the defendant committed breach of contract by denying to execute the sale deed. The breach of contract by defendant can be established if the terms of the contract are proved. Normally, agreement for sale of immovable property in India does not involve time as the essence of contract, unless, however, by expressed and overt statements, the parties make time as the essence. The valid agreement for sale must contain the terms and conditions in it which the plaintiff is to plead and establish, and thereafter to show which of the terms are violated or breached by the defendant. For instance, if time is not the essence of the contract, which is the normal case of agreement for sale of immovable properties in India, then defendant may not be guilty of breach of the terms of the contract for delay in pertaining his part, even if he fails to execute and register the sale deed on being offered by the plaintiff. Sale of immovable property cannot be made at mere desire of the parties. This is regulated by rules and guidelines framed by the government. This is important, my lord. The suit land falls in GMC area, and under such circumstances, unless and until necessary no objection certificate by the Deputy Commissioner and Development Authority is obtained, there is no question of execution for registration of a sale deed. In the absence of such no objection, sale and registration is prohibited by law. The plaintiff is surprisingly silent in regard to disclosure of such material facts. Besides, defendant's failure to execute and register sale deed within a given period of time may be fortuitous or caused by intervening circumstances, and this is why, unless and until defendant denies to execute the sale deed, the question of breach may not arise. Under such facts and circumstances, it may not be possible to hold that the defendant breached the terms of the contract. In the plaint in hand, neither the terms of the contract nor breach of any specific term has been pleaded by the plaintiff. As stated above, plaintiff is duty bound to plead and prove not only existence of a valid agreement for sale, but also breach of term of such agreement by the defendant. Even if plaintiff succeeds to prove the first two steps on way to establish a case for specific performance, the plaintiff is duty bound to plead and prove that he is ready and willing to perform his part of the contract. In any of these three steps is not established by the plaintiff, he may not be entitled to a decree of a specific performance of contract. It cannot be lost sight of that specific performance is a discretionary relief. Para 11, coming to the facts of the present case, even if it is assumed for the time being that the case put forward by the defendant as to obtain his signature on blank stamp paper is not established, and the plaintiff has succeeded to plead and prove existence of a valid agreement for sale, yet the plaintiff has failed to plead the terms of the contract and the fact that the defendant breached any of the terms. It is not a case of the plaintiff that the defendant has refused to execute and register a sale deed. There is no averment anywhere in the plain. The defendant has breached any of the terms of the agreement or that he did not agree to execute sale deed. Forgetting the case of the defendant for the time being and focusing on the averments made in the plain, it appears that only the allegation that of the plaintiff has labeled against the defendant is that the defendant has been delaying execution of the sale deed on baseless grounds. What are the baseless grounds are nowhere disclosed, and in the process, the court is handicapped to hold that the grounds put forward by the defendant as a reason for not executing the sale deed is baseless ones. The plaintiff miserably lacks in material facts. Resultantly, the plaintiff has failed to make out a cause of action for suit for specific performance of contract. This is because once plaintiff could not plead and prove that defendant breached any of the terms of the contract, cause of action for a suit of specific performance of contract cannot arise. None of the learned courts below had considered this aspect of the matter. And so substantive question of law was decided in favor of the appellant. Thereafter, my lord, paragraph 12, substantial question of law number 2, whether the suit is liable to be dismissed for non-compliance of provision of 16C of specific relief act. This is a suit for specific performance of contract. Section 16C of the specific relief act provides that the plaintiff must plead and prove that he is ready and willing to perform his part of the contract, as otherwise no decree for specific performance can be passed. In conformity with such legal requirement prescribed under Specific Relief Act 1963, the prescribed format for breach of agreement to purchase land has been laid down in form number 13 under Appendix A to the CPC in para 2 of the standard form of the plain for such suit prescribed so and so. In catena of decisions of the Honorable Supreme Court, the statutory requirement of such averment as to readiness and willingness has been emphasized. Para 12 in the case of so and so can be referred to in this regard, which is quoted as below. I'll skip this part, my lord. In the case of Motilal Jain versus Ramdas Devi and others, the Honorable Supreme Court has expressed that the intention of the plaintiff in regard to readiness and willingness is to be understood on perusal of the plaint in entirety. In a given case, such expression may not be in prescribed format, but yet the same may exist in other form. Here in this case, the aforesaid judgment does not appear to be applicable on facts. Nowhere in the present plaint it is stated that the defendant did not agree to execute the sale deed, although all along the plaintiff has been ready and willing. The Exhibit 1 also does not reveal as to who is to take steps for obtaining NOC. Here also similar to our case, my lord. Agreement Exhibit 1 also does not reveal as to who is to take the steps for obtaining NOC of the concerned authorities, which are preconditions for execution and registration of a sale deed with regard to immovable property. Normally, it is the purchaser who is to take the steps. Plaintiff is silent in regard to such performance as to obtaining no objection certificate from the appropriate authorities, that being the position, and in the absence of necessary material facts as referred to above, it becomes difficult to presume even upon perusal of the plaint in entirety that the plaintiff has substantially complied with the requirement of Section 16C of the Specific Relief Act 1963. So, my lord, situated thus similar to our case, my lord, here also the plaintiff.
No, is this finding backed by any of the decision of the Supreme Court that normally it is the purchaser who has to take the step? Where it is
Normally it is done.
nowhere it is provided.
But it is not provided by the law is not laid down like that, but
Law
normally,
is
normally, my lord, the purchaser, the vendee, he only
No,
takes the permission.
normally, that's why I am telling you, it is not backed by any statute or any rules or any
that is-
regulation or by any decision of the Supreme.
So,
It
my
is
lord,
as per the stipulation made in the agreement,
as per, but in the
but the agreement is silent.
silence, plaintiff is also silent. Only in the evidence part, they have stated that they have taken the permission. It was duty cast upon them to take the permission. PW2, 1, 2, 3, all of them have corroborated, my lord. So we have to go taking PW 1, 2, 3, we have to assume that they were the persons who were liable to take the permission. And their case is that, my lord, they have all along been ready and willing to pay 9.5 lakhs to the defendant, and the defendant in the month of December 2019 refused to execute the sale deed. Otherwise, in the month of December 2017, we did not refuse, my lord. So the balance sale consideration amount was rupees 18 lakhs as per them, my lord. If 18 lakhs was to be paid and they have offered me 9.5 lakhs, why would the defendant execute the sale deed, my lord? Because there was almost 8.5 lakhs less amount that was agreed upon by the parties, my lord. 33 lakhs was the total sale consideration. As per them, they have paid 15 lakhs.
There is no dispute that the sale consideration was fixed at
33 lakhs. There is no dispute, my lord.
No dispute.
No dispute.
And
That is-
according to you, they have paid you a sum of rupees?
According to me, they have paid a sum of rupees 5 lakhs. According, as per exhibit 1.
Yeah.
We are denying exhibit 2, execution of exhibit 2.
They have denied.
We have, the defendant have denied.
Okay.
So we have denied that there was no exhibit 2, that is, they have fraudulently executed exhibit 2, my lord. So even if assuming, my lord, that the exhibit 2 was executed, then 10 lakhs was paid as per exhibit 2. So total amount comes to 15 lakhs. So remaining amount becomes, my lord, 18 lakhs. And their case is that out of these 18 lakhs, they were always ready and willing to pay 9.5 lakhs. So where is the question of readiness and willingness to pay the entire sale consideration amount? Plus, they have failed to show any financial capability or any bank statement, income tax return to show that they had the financial capacity to pay 18 lakhs. Why that is important, my lord? That has been laid down in one of the judgment of the Honorable Supreme Court, my lord. 2019 9 SCC, page 132. Para 15, my lord. Last page, para 15.
Paragraph number?
15, 1-5, last page. Coming to the facts of the present case, the sole document relied upon by the appellant to prove her readiness and willingness is the approval of loan on July 30, 2004 by the ICICI. Such approval was subject to two conditions: furnishing of income tax documents of the appellant and the property documents. Messrs. ICICI has sent an email on May 12, 2005 to the husband of the appellant requiring an agreement to sale on a stamp paper of ₹50 to be executed between the parties as per the legal opinion sought from the appellant lawyer, without which ICICI will not be able to disburse the loan. Admittedly, no agreement was executed on stamp paper, and therefore the appellant could not avail loan of ₹50 lakhs from the ICICI. Independent of such loan, there is mere statement that the appellant and her husband have income of ₹80 lakhs per annum, unsupported by any documentary evidence. Such statement will be in the nature of ipse dixit of the appellant on her husband and is without any corroborating evidence. Such self-serving statements without any proof of financial resources cannot be relied upon to return a finding that the appellant was ready and willing to perform her part of the contract. The appellant has not produced any income tax record or the bank statement in support of a plea of financial capacity so as to be ready and willing to perform the contract. Therefore, mere fact that the bank has assessed the financial capacity of the appellant while granting loan earlier in respect of another property is not sufficient to discharge or prove a financial capacity in the facts of the present case to hold that the appellant was ready and willing to perform her part of the contract. Such is the finding recorded by both the court below as well. Here also in the instant case, they have failed to show any document that they had the financial capacity. They have merely stated that while they have collected an amount of rupees 9.5 lakh. If they have collected, that means they have taken from some other persons. So those persons were very much necessary to be adduced as evidence to show that, my lord, the plaintiff has taken loan from them so as to collect an amount of rupees 9.5 lakhs. Although that 9.5 lakhs is not the total sale consideration amount. So situated thus, my lord, this judgment squarely covers our case also, plus the judgment of our Honorable High Court, which I have cited earlier. So the finding that is given by the trial court that we have neglected to perform our part of the contract, that is a completely false and baseless illegal finding. Okay. Now, para 34 deals with tribal wealth, my lord. So tribal wealth, my lord, as I have already stated, I'll not go to, my lord, may directly come to page 55, paragraph number 41. From para 34 to para 40, my lord, elaborately the learned court has discussed about the tribal wealth, about chapter 10. The finding is at paragraph number 41.
Yes.
In the instant case, there is no dispute that the suit land falls under the Sidli tribal belt and block areas of the Sidli Revenue Circle, District Siran, BTR Assam, and the plaintiff is a permanent resident of District Kokrajhar, BTR Assam. There is also no dispute regarding the fact that the plaintiff belonged to Gorkha community having a caste of OBC. So this finding, my lord, from where the court has come to this finding, my lord, because there is no document to show that he belongs to Gorkha community, no pleading to that effect also. The Gorkhas are conferred the status of protected class in the tribal belt and blocks in the district of Kokrajhar, Sirang, Baksa, and Udalguri, provided they have been permanently residing in the aforesaid districts prior to 10th February 2003. No document to show that, my lord, prior to 10th February 2003, they have been residing. The plaintiff was residing. There is no averment, single whisper also, my lord. Just because the plaintiff is 50 years old, the court has held that, my lord, he is a permanent resident before 2003, my lord. The plaintiff was 50 years old at the time of filing the suit, and the defendant has not raised any question regarding his permanent residency prior to the year 2003 in the district of Kokrajhar. However, the DC of the concerned district is empowered by regulation to verify the condition precedent to purchase land prior to issue sale permission in favor of its owner. The plaintiff is a notified protected class of person, and therefore he has every right to purchase the suit land, provided he must be permanent resident of the Kokrajhar prior to the year 2003. The defendant has admitted the agreement dated 3/11/2014, which ensure taking of advance consideration money from the plaintiff in respect of the land in question. The defendant has intentionally deferred execution of the sale deed in favor of the plaintiff on several occasions, which led the plaintiff to file the present suit. The contract dated so-and-so was breached due to the conduct of the defendant, who was not willing to perform the contract after entering into it. Hence, the issue is deciding affirmative in favor of the plaintiff. So, my lord, this finding is completely perverse on the face of the record, my lord. Because, my lord, they have themselves stated in the cross-examination as well in the evidence in chief that they have applied for sale permission, but the permission was not given. Why it was not given? This is crystal clear, because they are not a person who belong to tribal belt, my lord, protected under Chapter 10 of the Assam Land and Revenue Regulation. That's why no permission was given. If no permission is given, my lord, how can I execute a sale deed? NOC and sale permission as signed on, my lord, for execution of a sale deed. So, my lord, situated does this finding in issue number 3, 4, 5, those are completely perverse and beyond the records, my lord. It was never a pleaded case. And one more point I had raised at the very beginning, my lord, that Exhibit 2 could not have been taken into admission because, my lord, it was a compulsorily registrable document under Section 35 of the Stamp Duty Act, my lord. In this regard, my lord, I have a judgment of Honorable Punjab and Haryana High Court. Second page, there are no paragraphs in this judgment, my lord. Second page, my lord, may come to. I'm reading from Section 35. Section 35 on the Indian Stamp Act 1899 reads as under Section 35, instruments not duly stamped inadmissible in evidence, etc. No instrument chargeable with duty shall be admitted in evidence for any purpose by any person having by law or consent of parties authority to receive evidence, or shall be acted upon, registered or authenticated by such person or by any public authenticity of this document, provided that, I'm skipping this part, my lord, next page, my lord. In case of Avinash, second paragraph, in case of Avinash Kumar Chauhan versus so-and-so, the said explanation has been inserted by MP Act so-and-so with effect from 15 November. By reason of the said provision, a legal fiction has been created. Although ordinarily, an agreement to sale would not be subject to payment of stamp duty, which is payable on a sale deed. But having regard to the purpose and object it seeks to achieve, the legislature thought it necessary to levy stamp duty on an instrument whereby possession has been transferred. The validity of the said provision is not in question. It is not in dispute that a possession of the property had been delivered in favor of the appellant. He has thus been exercising some right in or over the land in question. We are not concerned with the enforcement of the said agreement. Although the same was not registered, but registration of the document has nothing to do with the validity, therefore, as provided for authenticity of this document under the provisions of the Indian Registration Act 1908. Next paragraph. it is tried that the document that is required to be registered and which contains a recital of delivery of possession would also be required to be stamped as per the provisions of Indian Stamps Act 1899 amended by the state of Punjab. Keeping in view the law laid down, I do not find any illegality or infirmity in the order passed by the trial court in so and so. So well, here in our case also, as per the Exhibit 2, delivery of possession was given. In fact, a handle was also given to the plaintiff to go ahead with construction, to undertake any kind of construction. Since delivery of possession, the recital is there, my lord, so that document has to be registered. If it is not registered, it can be impounded, my lord. And it is not admissible in the evidence.
Except this judgment, there is nothing, nothing on the record to support your version.
My version about, my lord, registration.
Yes.
My lord, the law itself,
Except this judgment.
except the judgment, yes, my lord, because the law itself is saying, my lord, that once the recital of delivery of possession is there, then it has to be registered, my lord. And in fact, the plaintiff is completely silent. Why we are saying that Exhibit 2 is manufactured, my lord? Because they have stated about the payment of rupees 10 lakhs in presence of witness. Who were those witnesses? They have not produced as evidence, my lord. Then delivery of possession is there, whereas in the plain, they have again claimed for recovery of khas possession. That itself goes to show that, my lord, that Exhibit 2 was not acted upon by the parties. There was some doubt, some cloud regarding the execution of the document. Because on the basis of Exhibit 2, they are going to show that they have paid 10 lakhs more as advance amount. Since they have not paid, my lord, although our pleading was not perfect, but still they cannot take advantage of our.
Okay. Yes, Mr. Ghosh.
My lord, this case, my lord, regarding validity of, first point is regarding validity of Exhibit 2, my lord. My learned friend had said that since delivery of possession has been there, so registration is compulsory. Registration is compulsory on that count when I have claimed for Section 53A of the TPA. If I claim for Section 53A of the TPA, then registration is compulsory. If I am not coming for Section 53A of the TPA, I am coming for suit for specific performance of contract. Now kindly see the Registration Act, Section 17. Indian Registration Act, Section 17, 1A, 17, 1A, my lord. It was come in the year 2001, my lord. The document containing contracts to transfer for consideration of immovable property for the purpose of Section 53A of the TP Act shall be registered if they have been executed or after commencement of the Registration Act and other related law amendment in 2001, my lord. So it is not a case of Section 53A of the TP Act. What is, kindly see the Section 53A of the TP Act, my lord. Then only the compulsory registration, my lord. 53A, my lord, kindly see. Part performance.
Yes.
Part performance. Where any person contract to transfer for consideration of immovable property by writing signed by him or on his behalf from which terms of necessary to constitute the transfer can be ascertained with the reasonable certainty. So here it is when it is a case for part performance, my lord. It is not a case of part performance. So the contention which has been raised regarding validity or invalidity of the document does not arise in this case, my lord. Because it is a valid document, agreement for sale. It is not that I am claiming for suit for specific performance. I am claiming for suit for specific performance of contract. I am not claiming that part performance. So if it is part performance, then registration is compulsory under Section 17, my lord, of the Indian Registration Act.
Now with respect to my lord, kindly see regarding the permission. Kindly see the exhibit 2, paragraph 3. Agreement dated 27/1/2015. Para 3.
Yes.
In the said para, it is said that defendant has already started process for that is
Procuring
yes.
necessary permission.
So it is he himself in the agreement stated that he has taken necessary steps for taking NOC, my lord. That is the defendant.
As per this exhibit 2.
Exhibit 2. He said that I have to take permission, that part, my lord. My answer is that in the agreement itself, it said that defendant will have to started process for procuring necessary permission of NOC. And kindly see the written statement, my lord. Regarding tribal belt or all these things, my lord. In my plaint, I have specifically stated I am belongs to OBC category. And this tribal land cannot be transferred to the non-tribes. These are the contention he has been raised. In the written statement, there is no contention, such contention. Kindly see the written statement.
Okay.
Page 23 of the memo of the bill. Kindly see, my lord, the agreement itself admitted by in the written statement. Page 23 of the written statement.
Para 3.
Para 3. That the boundaries are also disputed. Hence, the present suit is not liable as per law. That instant suit is fall on tribal belt and block. So there is a caution for sale the disputed land to the third party. To the third party. And to dealing with this point, my lord, Chapter 10 of the Assam Land Revenue Regulation, the learned trial court has dealt with that this the plaintiff has by way of notification, the community of the plaintiff has been fall under that part has been dealt in the judgment. Paragraph 41, page 55. It is in the instant case, there is no dispute that the suit land fall under the Sidli tribal belt and block area of Sidli Revenue District, BTR Assam. Plaintiff is a permanent resident. Lordship got it? Kokrajhar, BTR Assam. In the agreement, as well as in the plain, everything, the address is the plaintiff is residing in BTR area. There is no dispute regarding the fact that plaintiff is belong to Nepali Gurkha community having the caste of OBC. The Gurkhas are confirmed as the status of the protected class in the tribal belt and block in the district of Kokrajhar, Chirang, Baksha and Udalguri, provided they have to be permanently residing in the aforesaid district prior to 10 February 2003. The plaintiff was 50 years old at that time of filing the suit and the defendant has not raised any question regarding this permanent residency prior to the year 2003 in the district of Kokrajhar. However, the Deputy Commissioner of the concerned district is empowered by the regulation to verify the condition precedent to the purchase the land prior to the issue of sale permission in favor of its owner. Plaintiff is a notified protected class. This is a clear finding. Notified protected class of a person and therefore he has every right to purchase the suit land provided he must be permanent resident of Kokrajhar prior to the year 2003. The defendant has admitted the agreement dated 3/11/2014, which ensured taking of advance consideration money from the plaintiff in respect of the land in question. The defendant has intentionally deferred execution of the sale deed in favor of the plaintiff on several occasions, which led to plaintiff file the present suit. The contract dated 3/11/2014 and 27/1/2015 was breached due to the condition of defendant who was not willing to perform the contract after entering into. Hence, this issue is decided so and so. Now, after in the materials available on record, I have stated that I have paid initially 5 lakhs, then in second agreement 10 lakhs, then one pro forma defendant took some amount on behalf of the defendant, main defendant. Then on the basis of that, my lord, I make an abatement that I will have to pay remaining balance 9,50,000. The court below held that no, since the payment to the third party has not been proved, so I will have to pay the remaining after deducting 15 lakhs, I have to pay 18 lakhs. And this was the judgment passed by the learned trial court that I will have to balance 18 lakhs within 3 months from the passing of the decree. Immediately they rushed to the before this honorable court by filing appeal. So though I offered, but it would not be taken up because of the pendency of this case. Because I will have to pay before the court. There is a direction.
This 18 lakhs.
18 lakhs. Kindly see last part of the order 59, page 59.
Now you are willing to pay the
18 lakhs.
the sum of rupees
18 lakhs. There is a clear finding.
Then
The
you
plaintiff
could not,
to deposit the balance amount of rupees 18 lakhs within 90 days from the date of judgment. The defendant thereafter execute the registered sale deed within 15 days. So immediately he came before this honorable court. So now the matter is sub judice, my lord. Now it is pending appeal, my lord. So I'll have to pay 18 lakhs. So there is an abatement in my plaint that I am ready and willing to the balance consideration amount. Though I have stated that I have to pay 9,50,000, but court came to a finding that no, I will have to pay 18 lakhs. And under such circumstances, my lord, whether my money, my amount, 15 lakhs has been proved as per the trial court that I have paid 15 lakhs. It was proved. And remaining payment, my lord, regarding remaining payment, in the written statement also, they have not denied anything, my lord. Kindly see the written statement.
Okay.
There is only simple denial.
Well, now they are not willing to accept rupees 18 lakhs.
They are willing to pay 18 lakhs.
Yes.
now.
He has already
Yes.
submitted.
Because as per direction of this court, I have to pay.
My
I have to pay.
main
18 lakhs.
contention was that, my lord, the agreement was, time was the essence of the contract, my lord, because there was an urgent necessity. That's why I was willing to sell the aforesaid plot.
That's what I am coming, my lord, regarding whether time
And
is
that's
the
why, my
essence
lord,
of
there was a
contract.
clause that within 3 months, that is 28 to 2015, he has to pay the remaining balance consideration amount, which he has not done. So thereafter, my lord, I do not say that the exhibit 2 that was 10 lakhs that was paid to me, that was executed by me. That was fraudulently obtained. So although they are now willing to pay 18 lakhs, my lord, but my main necessity at that point of time, that was not taken care of by them. Situated does, my lord, that's why, my lord, they are not to get the discretionary relief, specific relief tax. Because it's mainly in the nature of discretionary relief, my lord. My lord wishes, my lord may grant. But the question is that since they have themselves neglected to pay the sale consideration amount within a reasonable period of time or within the fixed period of time, that's why they are not eligible to get the discretionary relief.
My lord, one judgment I am relying regarding time is the essence of contract or not, my lord, in such a case. 2011 12 SCC, page 18. Paragraph 17, 18 and 19 can list.
Paragraph.
17, 18, 19. My lord, short, long judgment, my lord. The appellant contended that time is not the essence of agreement for sale dated 17/1 so and so. See,
You are reading paragraph number?
my lord, 17 in the online copy, it is 17.
This is printed version. What is the initial line?
Ek minute. My lord, party's name, my lord. ठीक है party is Sharda Muni.
That's all right.
Yes, yes.
No, what is the initial line of that paragraph?
Paragraph 17. Yes. Read question number 1. After formulating question.
Yes.
16 is feeling aggrieved by the judgment. Then.
No, the issues.
Yes.
After issues,
yes.
the suit for refund of rupees 1,25,000. Following issues were framed.
My lord, relying upon observation of the court of so and so. Paragraph 18 is relying upon observation.
After feeling aggrieved, question number 1.
And then thereafter, next paragraph. Yes. Feeling aggrieved, then next paragraph. The appellant contended that time is not the essence of agreement of sale dated 17/1/1981. She contended that where the vendor failed to give the documents of title to satisfy the purchaser about their title and the purchaser is ready and willing to perform the contract, the termination of the agreement for sale by vendor is illegal and amounts to 16 to breach of the contract. Here in the case also, he is now claiming that it is a tribal belt, I cannot sell it out. So this is a breach of contract. Is perform the contract, termination of the agreement of sale by the vendor is illegal and amounts to 16 breach of contract. They submit that High Court had failed to apply Section 55 of the Contract Act. So Section 55 of the Contract Act deals with the effect of failure to perform the fixed time in the contract in which it is essential. Said section is extract below. This Section 55. Then thereafter, the above section dealt with the effect of the failure to perform at a fixed time is in contract in which time is essential. The question whether time is the essence of contract with reference to performance of a contract, what generally may arise for consideration either the reference to the contract as a whole or with reference to a particular terms or condition of the contract which is breached. In the contract relating to sale of immovable property, if time is specific for payment of the sale price 17, but not in regard to the execution of the sale deed, time will become the essence only with reference to payment of sale price, but not in regard to execution of the sale deed. Lordship got it? Execution of sale deed. Normally, in regard to contract relating to the sale of immovable property, time is not considered to be the essence of contract unless such an intention can be gathered either from the express term of the contract or impliedly from the intention of the parties as expressed by the terms of the contract. Relying upon observation of this code in so and so, so and so, in the contract relating to immovable property, time cannot be the essence of the contract. The appellant put forth the contention that in all contracts relating to sale of immovable property, time is stipulated for performance, even if expressed to be the essence, has to be read as not being the essence of the contract, and consequently the contract does not become voidable by the failure of the perform before the specified time. A careful reading of the said decision would show that the sentence relying on so and so apparently was not a statement of legal position, but a conclusion of fact regarding the contract that was being considered by the court in this case. With reference to in terms, it is in fact, the legal position is differently stated in para so and so, so and so. Then paragraph 19 also, the legal position is clear from the decision of Constitution Bench of the so and so, wherein the court outlined the principle thus. It is well accepted principle that it is the case of sale of immovable property, time is never regarded as the essence of contract. In fact, there is a presumption against the time being the essence of contract. This principle is not in any way different from the obtainable in England. Under the law of equity, which governed the right of the parties in the case of specific performance of contract to sell real estate, law look not to be letter, but the substance of the agreement. It has to be ascertained whether under the terms of the contract, the parties named a specific time within which completion was to be take place. Relying the substance, it is the intent that it should be completed within a reasonable time. An intention to make time as an essence of contract must be expressed in unqualified language. This is the findings of the Constitution Bench. So here in this case also, I am arguing that time is not, though in first agreement, there's some time limit has been given, but in second agreement, after accepting 10 lakhs rupees, there was no such stipulation. And even if it is there also, for the purpose of execution of the sale deed, time is not the essence of contract. Only for payment, it may be, my lord, as per the judgment, my lord. Now, here in this case, my lord, another point, my lord, regarding which the learned friend has raised, regarding tribal bill, and that I have already point out that this point has already been dealt with by the learned trial court, my lord. So under such circumstances, there is no error, and no interference need not be required, my lord. And in the written statement, kindly see, they are specifically admitted with respect to agreement, my lord. In paragraph.
First thing. First thing.
That the statement made in paragraph 3 and 4 is partly admitted, as because answering defendant never goes to the plaintiff regarding where this contract was, that part, his plot of land. That the plaintiff himself was not was come to the answering defendant to purchase the disputed plot of land and other than matter of record.
Okay. Any reply, Mr. Iqbal?
Just 2 minutes, madam. But my learned senior colleague has stated that time is not the essence of contract and has cited the judgment also. But that is.
No, is there any such stipulation in the second agreement?
First agreement, there is, second agreement, it is not there.
Not there.
But my lord, para 3, if I read from the plain, I just point out one thing. my lord.
Para 3 of?
The plaint. Page at 12, page 12, that the plaintiff now begs to submit that with view to sell the below mentioned scheduled suit land, it is the defendant who had met, visited and approached the plaintiff on and around the middle week of month of October 2000 and requested the plaintiff to purchase the suit land as he is in great necessity of money. So I was in great necessity of money in the year 2014. Now it is 2015. 2014, we had entered into an agreement, and in the first part of 2015, he had come with the money of 9.5 lakhs in the year last part of December 2017, my lord. From 2014 to 2017, he had not approached me, either with 1 lakh, 2 lakh, or 3 lakhs. Not a single penny was given to me, my lord. I had urgent necessity at that point of time. Now 3 years have gone by, they have not come by, and now they have straight away filed a suit in the year 2019, my lord, saying that, my lord, I have failed to discharge my part of the contract. What about your contact, your participation, my lord? That is not there, my lord. Because I cannot keep on waiting. The price escalation point also has to be seen by the courts, my lord. Now it is 2025. The agreement was entered into in 2014. Prices have shoot up, my lord. Now they are willing to pay 18 lakhs, my lord. But whereas their case is that the main trust is that they are willing to pay 9.5 lakhs, and 9.5 lakh was the balance sales consideration amount. After passing of the judgment, they have now accepted, no, 9.5 lakhs is not there. 18 lakhs are we had to pay. We are ready and willing to pay back. That's what. So that itself goes to show that, my lord, they have not come approach the court with a clean hands. My lord. And regarding Gorkha, my lord, that thing is there. Just merely stating a line that I belong to OBC, would that suffice, my lord, without any documents to show that he's a person belonging to Gorkha community and he's a permanent resident before the year 2003?
Kindly say exhibit B, Mani. Certificate I have.
Exhibit?
Exhibit B.
Oh, respectful submission is, my lord, discretionary relief should not be given, my lord. Seeing the escalation of price also at this point of time. Already 11 years have gone by. If I
Did it, Mr. Bose?
Exhibit B.
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 It is in the record of the trial court?
Yes, yes.
exhibit 1, 1 to 3, 4.
Aman is good.
Oh, 1, 2, 3, 4 क्या है बोलते?
Kindly.
Okay.
My lord, there are only 3 as per the judgment, my lord, at page 61, there are only 3 exhibits that were exhibited by the respondent. Exhibit 1.
B is there?
My lord, B, it's written as
B.
exhibit 1, 2, 3, 4, my lord. Exhibit 1 is the first agreement for sale. Exhibit 2 is the second agreement for sale. Exhibit 3 is the money receipt. Exhibit 4 is the nothing, only 3 exhibits. Even in my copy, my lord, certificates.
Yes, yeah. Page 61.
61, more target.
Page 61.
Is this, my lord, that is a completely different certificate. That is certificate showing that, my lord, Sidli, that is the Suitland, falls in the Sidli tribal belt. That is not a certificate showing that he belongs to Gorkha community.
No, may not be, but he's living in that place.
Exhibit is a exhibit B is from our side, my lord.
Yes.
अपने का रसम है. Who? It exhibit B. My lord, exhibit B is etu nahi bana. Exhibit B, my lord, is a certificate showing that this is to certify that village Boikundgaon falls under Sidli tribal belt and block areas of Sidli revenue circle. So here it is nowhere stated that the plaintiff is a resident, my lord.
In the agreement.
The disputed land falls, my lord. That is, we also admit.
Even in the plain, in agreement.
Address given in the plaint was of the year 2019, that he resides before the year 2003, my lord. Where is the proof, my lord? He could have very well produced PRC, my lord. Exhibit B is not going to help them.
He has not come up with a list of counterclaim that the agreement for cancellation all this.
I need not make.
But Mr. Iqbal, learned counsel for the appellant and Mr. S.K. Bose, learned counsel for the respondent are concluded, judgment is in.
Deeply obliged.
Item number 11 by DC.
May it please, my lords, my apologies, I was not available on the first call.
Yes.
Lordship. Lordship, can I have a minute, Lordship? Lordship, before the learned senior counsel submits his submission, Lordship, I want to submit something. So, Lordship, on the last occasion, Lordship, the learned senior counsel for the appellant has stated that he has paid the court fee, Lordship. But Lordship, today morning I have take the court record, Lordship. The court fee in the name of court fee, Lordship, only 22 rupees is paid by them, Lordship. But Lordship, as per the court fee, Assam Amendment Act, Lordship, if the memorandum of appeals value exceed Lordship 50,000 of rupees, then Lordship, a amount of 11,000 is to be paid as a court fee, Lordship.
My lord, we have paid a court fee of 11,000 rupees. I don't know from where my learned friend here is coming, because I had personally made that payment after meeting the registry where they had said the ad valorem court fee would be, madam, let me.
Yes, yes, sure.
My lord, this issue will be laid to rest here itself in the e-courts, my lord. The court fee paid is on 29/5/2025, my lord. Court fee has been paid by Power Grid. And there is a receipt also to the same, my lord. I will also produce that. So, my lord, this thing would not hold any ground because we have paid the court fee. It is there on record. Ad valorem court fee of 11,000 rupees was paid by us. I have the receipt also, my lord. If I may, my lord, just.
Yes, you can send it to the court counsel.
I'll need it. Yeah, I have it.
Lordship, I have checked the file, Lordship, and I didn't find any folios, Lordship, and also any online receipt, Lordship.
My lord, the matter may proceed. In the meantime, I'm mailing it to save the time of the court. I have it. Matter may proceed.
My lord, I have already made my submissions. I just want to show one judgment to my lords of the appellant before the petitioner before my lords, a similar case where, my lords, we were not made a party to the execution, the proceedings, sorry, before the reference court, my lord. And then the matter travels to the High Court, and this honorable court, my lords, the judgment is PGCIL versus Parbat simply. And this is, my lords, reported judgment. The judgment is dated 1st of June 2025. My learned friend in the court will hand over a copy to my lords because the fact situation was exactly the same.
Okay. Yes, what is the number?
My lords, this is it's a certified copy of the judgment, but we do not have the reported judgment. This is a certified copy. My learned friend already has a copy in the court, my lord. This is of this honorable court, my lord. When it was a court of all the 7 states, my lord. It's a division bench judgment, 1st of June 2025, my lord. The facts are exactly the same. And my lords will kindly come to the last page. I don't want to trouble my lords with the other judgments which are quoted. My lords, the Supreme Court judgment is quoted. My lords will come to the last page, para 11. Relying on my lords Himalayan Times and Marbles, it says that this court is of the opinion that the appellant is entitled to a notice and a chance to be heard before the reference court to present the case with regard to the amount of compensation to be determined by the reference court. This is also in consonance with the principles of natural justice, equity, and good conscience, in view of the fact that the compensation has to be paid by the appellant corporation. The case therefore requires to be remitted back to the reference court for fresh trial. And in para 12, my lords, the impugn order is set aside. And my lords, the case is remitted back to the reference court. And the reference court shall implead the appellant Power Grid, that is us, my lord, against the petitioner before my lords, by issuing notice to the appellant and also afford an opportunity to the appellant to contest the claim of the respondents in the case, whereafter to pass appropriate orders in accordance with law. So
Okay,
this,
okay, Mr. Sharma, okay. Yes,
Hello.
madam, Power Grid Corporation is one of the stakeholder in this proceeding.
Yes, Lordship. Yes,
So, they have not been implicated as party before the reference court.
yes, Lordship. Lordship, just because Lordship in the Land Acquisition Act, Lordship 1894, Lordship, if any land is acquired, Lordship, then all the power is vested upon the Deputy Commissioner. He has the power to inquire the matter and the payment of the compensation, Lordship. If any compensation is payable, then that award may be made by the Deputy Commissioner under Section 11 of the Land Acquisition Act 1894, Lordship. And Lordship, at the time of making the reference case, Lordship, Lordship, we have followed a format, Lordship, which is in the petition of reference under Section 18 of the LA Act of 1894 in Form 4, Lordship. Lordship, this is the form. Lordship, this is the format on which a reference case should be filed, Lordship. And we followed that format. And Lordship, in that format, as all the power is vested upon the Deputy Commissioner, Lordship, there is nothing that any opponent party has to be made a party, Lordship. And Lordship, if may allow, Lordship, I want to reflect my case from the very beginning, Lordship, in the year, from the very beginning, Lordship, in the year from 1999, Lordship, when the Lordship, our government allotted 8 bighas of land to each of the 27 number of tea planters, Lordship, who are the respondents in the appeal, Lordship. Lordship, then Lordship, in 2006, then Lordship, Power Grid acquired a land of 254 bighas of land for their project, Lordship. And upon that 254 bighas of land, the land of the respondents are also acquired. Then Lordship, what Power Grid did, Lordship, they filed a petition before the Deputy Commissioner that they are going to pay only 60,000 of rupees, Lordship, as a shifting of grant, and no other compensation are payable to the respondents, Lordship. Lordship, this is the letter from the Power Grid Corporation to the ADC, Lordship, Additional Deputy Commissioner of Sonitpur District. Here, Lordship, they have clearly stated that we are not entitled any other compensation and rather than the 60,000 of rupees.
No, madam, we are not on the merit of the case.
Yes, Lordship.
The question is whether Power Grid Corporation is a necessary party or if
Lordship,
necessary,
Lordship.
whether whether it's sustainable or not.
No, Lordship. Lordship, because in reference proceeding, Lordship, all the powers is vested upon the DC, Lordship. He is the only one who is going to pay us, Lordship. Lordship, although the Power Grid is a beneficiary, Lordship, but we are not seeking any compensation from the Power Grid, Lordship. We are seeking the compensation from DC. DC has to pay us, Lordship. That's why, Lordship, first time that award of 60,000 is made by the DC to us. Then, Lordship, we prefer a writ petition that is registered and numbered as 5529 of 2009, Lordship. But in the year 2019, that writ petition is withdrawn with a liberty to file a fresh. Then, Lordship, we again file a writ petition that is registered and numbered as 856 of 2019. And Lordship, in that writ petition was disposed of in the motion proceeding, Lordship. And Lordship, in that order, the Honorable High Court has stated that we are the person interested, and Lordship, we entitled for compensation. So, Lordship, and the court directed us to prefer an application before the Deputy Commissioner. And if the Deputy Commissioner may prefer, then Deputy Commissioner can refer the case to the reference court, that is to the Principal Civil Court. So, Lordship, within 6 weeks, we filed an application before the Deputy Commissioner, and after perusing the record and hearing the parties, Lordship, the Deputy Commissioner referred that case to the Principal Civil Court of Sonitpur District, Lordship, as at that time there is no Principal Civil Court in the Biswanath Chariali, Lordship. And Lordship, in that reference court, Lordship, we have made priority only to the DC. Just because, Lordship, in the Land Acquisition Act 1894, there is a provisions of Section
20, Lordship, the service to notice.
Hmm.
Section 20 of Land Acquisition Act 1894, service to
No,
notice. Lordship.
you tell me land was acquired under which provision of law?
Lordship,
Under which act the land was acquired?
Lordship, under Land Acquisition Act 1894.
1894.
Yes, Lordship.
When it was acquired?
Lordship, in 2006.
2006. Okay.
So, Lordship, in section 20, that is service to notice. If we see this section, Lordship,
Okay, you are referring to section 20.
yes, Lordship, section 20 is service of notice. So, Lordship, this section says about to whom service is to be served in a reference court proceeding, Lordship. Here, Lordship, it is mentioned that to the applicant, then Lordship, the person interested, that are the respondents, and Lordship C, that is the collector, Lordship. So, these are the persons to whom we can serve notice under a reference proceeding, Lordship. And Lordship, in this act, Lordship, there nowhere it is mentioned that a corporation has to be made as a party, Lordship. And Lordship, at the and also Lordship, I have already stated that at the time of preferring the reference proceeding, Lordship, we have followed that format which is already given. So there is no provisions of Lordship implement of a party to the beneficiary, Lordship, to implement the beneficiary as a party, Lordship. Then again, Lordship, in the memo appeal filed by the appellant, Lordship, kindly come to the page number 42.
Yes.
Lordship, the appellant has stated that the DC was maiden party and DC.
Page number?
Lordship, on the last location, appellant has referred the annexer 11, above the annexer 11, Lordship. This is the petition filed by the additional deputy collector before the district judge, Lordship, for implement of the power grid as a party in the reference proceeding, Lordship. And upon this petition, Lordship, we have filed an objection petition, and this is the objection petition in annexer number 12. And Lordship, kindly come to the page number 142. Here, Lordship, we have mentioned why we didn't make the power grid as a party in our reference proceeding. In page number 42, Lordship, 142.
Yes.
Lordship, leave may be granted to read para number 2, Lordship, last portion. It is pertinent to mention here that neither the beneficiary, that is the Power Grid Corporation of India Limited, nor the learned deputy collector is a necessary party for their implement in the instant reference proceeding because of the fact that Order 1, Rule 10 of CPC has no application to the reference proceeding under Section 18 of the Land Acquisition Act 1894, as held by the Honorable Allahabad High Court on 11/1/1991. Between Gorakhpur Development Authority versus District Judge Gorakhpur and others reported in AIR 1991, all 141 para 17 and 18. After considering and relying upon the various judgments of the Honorable Supreme Court of India as well as different high courts, it is further stated here that the proceeding before the reference court under Section 18 of the Land Acquisition Act 1894 is not really a continuation of land acquisition proceeding before the collector, and earlier records do not form part of the case before the court of law, and accordingly it is an independent proceeding having no essence of memo of appeal as reported in AIR so and so lordship. However, in the instant reference proceeding,
Anyway, what order was passed upon this petition?
lordship, no order was passed. No
No
order
order
was
was passed.
Yes, lordship.
The
Direct
petition
the
was
matter
neither
was,
rejected nor allowed.
no, not rejected nor allowed, lordship. Lordship, this is the petition we have filed.
This is your objection.
Yes, lordship. This is our objection. Lordship, after hearing this objection petition, lordship, the matter was directly fixed for hearing, lordship. As lordship, there is no provisions for implement of Power Grid as a party in reference proceeding, lordship. So matter was directly fixed for hearing.
Lords, may I just clarify, there's a Supreme Court judgment, my lords, which is pat on the point, which clarifies this issue. My learned friend may not be correct in stating the law. My learned friend will pass on the judgment of Neyveli Lignite, that the beneficiary is a person interested under the Land Acquisition Act and hence a necessary party. My lords, this is Neyveli Lignite Corporation versus Special Tehsildar. This is my lords, a three judges case. My lords, it has been relied upon in a series of judgments, but this is the judgment. My learned friend will hand over a copy, my lord. 3 judges of the Supreme Court, my lord. May I place that, my lord?
What is the citation?
My lords, the citation would be. What is the
My lord, I'll provide the citation. I'll provide.
Just hand my learned friend could just hand over a copy to the court. It's not coming from the. Yes, my lords, this is 1994 supplementary volume 4 SCR, page 567.
Volume number?
4, my lord, supplementary volume 4.
Yes.
1994 supplementary volume 4 Supreme Court reports, my lords, page 567. I'm sorry, I'm not carrying the SCC equivalent of it. Can you just pull it out?
Okay.
May I just read that for my lord's consideration?
Yes.
My lords will come directly to page. The internal page of the reporter is 578, my lord. Between placetum C and placetum D, my lord. I'm sorry, let my learned friend hand over them. My lord has a copy.
No, copy is not available.
I am so sorry, my lords. I was told that the copies are available with my learned friend. That is why I took the liberty of citing it, my lords. Otherwise, I would have not done that. Because the judgment is clearly on the point, my lord. So I wanted to satisfy my lords on this issue. And therefore, the judgment of PGCIL of this honorable court, which I showed to my lord, it relies on Himalayan tiles, my lord. The Himalayan tiles is the base case, my lord. And this judgment also relies on Himalayan tiles. So I wanted to place the law exactly for my lord's consideration.
Mr. Sharma, let us do one thing.
My lord.
We adjourn the matter for today.
Lordship.
In the meantime, let learned counsel for the respondent go through the decision.
My lord. Yes,
that will be fine. We will take it up on Monday.
Or my lords, we could just file the submissions with the judgment if that is that appeals to my lords. We could cut short my lord's time and we will just place the judgment for the court's consideration, or whatever, as my lord pleases.
Or Tuesday then, probably. Okay, Mr. Sharma, Tuesday?
Can it be Wednesday then, my lords? If not,
Wednesday, okay.
Wednesday. I'm
Hearing, madam, you please go through this judgment. of-
Yes, Lordship.
Come back.
Yes, Lordship.
Hearing matter on Wednesday. Hearing matter.
Thursday then, my lords. My lords will fix it on Thursday.
Thursday.
Next Thursday.
Okay, Thursday.
On 31st.
Third, Mr. CP Sharma.
Lordship,
Secretary.
Lordship, if the matter is fixing on 31st, then kindly on one Lordship, because at that time my senior will come from
Tuesdays and Thursdays.
Thursdays only.
There's just, sorry, I'm sorry to interrupt the proceedings, my lords. So there's one problem. The execution proceedings are listed for 28th of July, my lord, as I pointed out on the last occasion. So that is the problem, my lord.
28 Monday. Friday, kal din ko. Kal din.
Then Mr. Sharma, tomorrow?
Tomorrow, my lords. Tomorrow, my lords will fix it tomorrow.
Okay. Okay. Excuse me. Okay, tomorrow.
Tomorrow, my lords. I'm deeply obliged, my lords.
Madam, you got the citation?
No, Lordship, didn't get.
I'll give the citation.
Jaldi pathao.
Next.
Obliged.
Item number 19.
Yeah, please.
Lord, before my learned senior friend starts, Lord, I'd like to highlight that, my lord, I'm appearing for the respondent, my lord. Mr. S. Bothak was supposed to appear here, go to division bench, my lord. I'm appearing on his behalf. My lord, before he starts, my lord, there is a writ petition which has been filed. Writ petition number 6628/2024, my lord. It is exactly on the same line, the prayers made in this particular petition, my lord. So I
WBC number?
6628/2024, my lord. Between same parties. Jyoti Kolita Bora has filed it against Guneshwar Bora, Deepika Bora, Deepshikha Bora, and state is also a party in there, my lord.
It is number
6628/2024.
WPC, no?
6628/2024. Okay. So if, my lord, that record is also before this honorable court, because it's on the same line, my lord. The prayers made in this particular petition, and the prayers here are the same, my lord. They have also sought for, my lord, the pension, my lord, in that particular case.
Here before this honorable court, in this case, that is a writ petition. Here is a case against a judgment passed by the district judge on succession certificate claimed by the respondents as the applicant. So here we are, as an appellate court, we are addressing this honorable court, whether the judgment is sustainable. A writ jurisdiction is totally different. This is a jurisdiction of an appellate jurisdiction to sustain the judgment of the.
Yes, it is appellate jurisdiction.
Although the contents of the.
But that is a totally different writ jurisdiction, your lordship. I have nothing
What
to
is the
say.
prayer in that petition?
My lord, that is what I wanted to read for, my lord. This is regarding the petitioner for release of the compassionate family pension, and other pensionary benefits included in the service benefit. Now, if I may take my lord to the present petition, my lord.
This is not an appeal.
It's the same, my lord, because if
it is
my
their
lord
case,
is
they have.
No, it is not. It is filed by you, not by me.
No, not this.
No,
The
writ
succession
petition-
certificate.
writ petition
the
has been filed
application
by
was
you.
filed by you.
Writ petition has been filed by you. That is the reason why I'm highlighting. Because the issue in both the cases are same, my lord.
Here is whether the appellate court will sustain the order of the trial court, your lordship. Whether the family pension under the Assam Pension Act will be there or not, that is a writ jurisdiction, that is cannot be. Both the cases are on different footings, your lordship.
May I please take my lord to page number 31 of the present petition?
Page number?
31, my lord.
31.
Yes, my lord. Here's the schedule, my lord. The succession certificate has been sought on this particular, my lord. The schedule. And the issue in, this is both regarding to, my lord, the same, the pensionary benefit of the, my lord, the deceased person, my lord. It is regarding the same, my lord.
No, maybe, but Red Court cannot exercise this jurisdiction, no? Now we are testing the judgment passed by the learned trial court.
My lord may very well move ahead, my lord, but my only consider is that if that case is also before my lord, then it would be, my lord, beneficial for us to at least address the court, because the issue in both the cases are same. It is regarding to the pensionary benefit of the same person. The writ court also is the same issue. Here, this particular court also the same issue. The succession certificate has been given to all of us, which he has come before this honorable, challenging which he has come before this honorable court. It is regarding the same pensionary benefit, the retirement benefit of the my lord.
Time and again, I'm saying.
The my lord, person. And he has also filed the writ petition as regard to the same my lord, the pensionary benefit of the my lord. So if both the files are before my lord, then it will be easy, my lord. If required, both the cases can be disposed of together, my lord. That is what I leave it to my lord.
An appellate thing, that is not fair. And if he has anything, this is a different thing. What I'm trying to say, I am before this court assailing a judgment passed, and this honorable court sitting in the appellate stage will hear the matter on appreciation of the impugned judgment. Now, whether the subject matter is same or not, that is a totally different thing. Yeah.
Rest I leave it to my lord. I had to highlight, my lord. I have apprised the court regarding this.
No,
Otherwise, also I'm.
The problem is that I don't think that a Red Court will exercise that jurisdiction.
Issue.
Will entitled to
My lord,
this pensionary benefit.
succession, no doubt the succession certificate part is different, my lord. Only this particular, this court has, honorable court has, my lord, jurisdiction as regard to the succession certificate which has been issued. But the issue regarding the pensionary benefit is of the same person, my lord, before the writ court as well as this particular court. Because tomorrow, if the court,
No, Mr. Sensua, you see, that is under 226.
Yes, my lord.
Under 226, you cannot question the legality, propriety, or otherwise of the
Certainly,
decision of
certainly,
decision
yes, my
passed by the judicial court.
Yes, my lord.
It is not maintenance.
Yes, my lord.
Then
Absolutely, my lord. But
ultimately, that writ petition would be infructuous,
my lord,
according to
then,
my view.
Then, my lord, if they withdraw the writ petition and come before this honorable court, if they say that they withdraw, my lord,
I'm telling I cannot be, means I am having two scopes.
No,
If I have filed, this is challenging that.
No, you cannot insist upon him to
No,
withdraw.
absolutely not. I'm merely apprising this honorable court.
This
as
is
regard
nothing
that this is
appraisal,
the
try
issue,
to
my lord.
confuse the honorable court. I'm very sorry to say.
Otherwise, I'm ready with this particular case. I have no problem, my lord, to argue. It is my duty to
let me
highlight this
argue.
before this
You have
honorable.
apprised this court.
If my lord wants to hear it, I'm ready, my lord. I do not have any problem.
Well, let us see.
Yes,
Yes. Now, your lordship, this appeal, which we have filed, your lordship, under 384 of the Indian Succession Act. Now, this is against judgment dated 30th of April 2020.
372.
Pardon me, lordship.
372 section.
No, 384, I think it would be the appeal provision.
Appeal, okay. Appeal
will
is
be-
under section 384.
It will be an appeal against an order passed by the district judge in the Succession Act, your lordship.
Yes.
Three 384 appeal.
Yes.
Now, before I will take your lordship directly to page 20 of my memo of appeal. This is the judgment by which a joint succession certificate was issued against both the parties. Now, before that, I will again take your lordship to Annexure B. This is the application which was filed under section 372 of the Indian Succession Act, on the basis of which this impugned judgment was passed. That is at page 29. Now, I will just give a background. Here, your lordship, the appellant before your lordship is the wife of one late Shubal Bora, who died while serving in the Assam Reserve Police Force as a Nayak in 2/7/2018. Now, the appellant was the second wife, means after the demise of his first wife, he married the appellant before your lordship. And at that time, the children were minor, and that is also admitted in the judgment. Both the parties have admitted to that. Now, what has happened is, the application was filed by the mother of the deceased and two daughters of the first wife. Lipika Bora, who is a married daughter, and Dipshika Bora, who at that point of time is said to be an unmarried daughter. Dipshika Bora. Now, here your lordship will find and this application, your lordship will find, is under 372. Now it is, if your lordship takes up 372, section 372,
Yes, it is regarding issuance of succession certificate.
yes. Now, it is a settled law of our High Court that pensionary benefit through succession certificate cannot be granted. This is a specific plea we have taken in our WS. Your lordship will come to page 33, Annexure C, where we have taken a plea with regard to, though not in an elaborate manner, the petition for the petitioner is not maintainable under section 372 Indian.
Page number?
Page number 33. This is the WS of the appellant before your lordship. A specific law point was urged. 372.
Paragraph number.
Second para, your lordship, single line.
Okay.
I'll take a place two judgments by our Honorable High Court, which clearly says that succession certificate under 372, because it runs from 370, cannot be said to be death or security. कर्नाटक है तो केरला है. Now, our Honorable High Court, while interpreting section 370, your lordship, I'll take your lordship first to the judgment of our Honorable High Court passed by late Justice Nishidendu Chaudhary. Now, I will take your lordship directly your lordship may come to para 10, your lordship. It would be page number 4. If I may take your lordship there. Under section 371 of the Act, the learned district judge under whose jurisdiction the deceased ordinarily reside has been given jurisdiction to grant certificate, and section 372 Act provides the context of the application. 372F shows that the must mention the debts and security in respect of this. Thus, a perusal of section 370, 371, 372, it appears that a succession certificate is available only in regard to debt and security left behind by the deceased. Securities are also specifically defined under section 370 within bracket 2. Prima facie benefit of family pension has nowhere been mentioned in the section as quoted above. In clause 70 within bracket 2, there are as many as 5 clauses such and such. Clause subclause 2A to 2D forms a definite genus like promissory note, debenture, stocks, and other securities, bond, etc. Applying the principles of Ejadiamus genus, clause E must be of the same genus to which the provision of either subclauses, namely 2A to 2D, belong. The benefit of family pension does not come in any way within the same genus as that of a promissory note, bond, debenture, stock, and other securities of the central government or state government, etc. So by no stretch of imagination can be held to be a debt or security within the meaning of Part X of the Act. Thus being the position, it is to be held that family pension, not being a debt or security within the meaning of Section X of the Indian Succession Act, no succession certificate can be granted under 371 of the Act in respect of benefit of family pension. This is the law that is there of our Honorable High Court. And this has been reiterated by the Kerala, though I need not go into it. The law is settled that family pension cannot be made a subject matter of a proceeding under 371 of a succession certificate, because family pension by our High Court definition, it is clear that it is not a debt or security. Now, taking that into account, I have taken a specific ground in our appeal that this learned court below could not have issued it because that was not a debt or security, and that particular provision ground, your lordship will find is ground number 3 of my memo of appeal. At page 10, it starts. Page 10, and it continues in page 11 of my memo of appeal. Here, for that the learned trial court has seriously erred in law as well as in facts in allowing the application filed by the opposite parties herein to seek a succession certificate in connection with the deaths and such as by no iota of evidence can be constituted to be debts of security. This is the ground I have taken, specifically assailing the impugned judgment passed by the learned trial. Now, that apart, your lordship, even if your lordship says that that can be considered, then also another point which I'd like to draw your lordship's attention is with regard to various judgments of the apex court as well as our high court, which clearly says that pensionary benefits are to be given on the basis of the rules governing such pensionary benefits. It cannot deviate from that. Your lordship may kindly take the pension code. Assam Service. I will take your lordship to some specific provisions before I make my submission with that. Lordship, if your lordship may be kind enough to come to rule number 143.
Yes.
Your lordship has got it. Family pension, for the purpose of the rule in this section, will include the following relatives of the officer. Now here, an application was filed, as your lordship, I had drawn your lordship's attention, by the mother of the deceased and 2 daughters, one of whom was married and the other unmarried, and the wife of the deceased. Now, both are married. Okay. Both are married, your lordship. Both the daughters are married. Now, your lordship will find section 143. Family pension for the purpose in this section will include the following relatives of the wife of the officer: wife in case of a male officer, minor sons, and I'll skip B because that is there. C is minor sons, and D is unmarried minor daughters. So these are the 3 categories which of family pension under the Assam pension rules, the family pension can be disbursed. Now, that apart, your lordship will come at the bottom, your lordship will find number 3, Roman 3. Your lordship has got it.
Yes.
Pension awarded under this rule in this section will not be payable to more than one member of a family, officer's family at the same time. These 2 points would be taken note of by this honorable court, your lordship. And now I'll take your lordship to the Oh, 143. 423. I know. Now here there is my colleague says to draw your lordship's attention that at the bottom of that number 3, that it would be first admissible to the widower and thereafter to the minor children. Now, as there is no minor children, I did not raise that point, but the fact remains that only one person, even if there were 3 persons in the eligible list, only one certificate to those persons could have been granted. Here, your lordship will find that the applicants who had filed this at page, the applicants who had filed the application at page 29, Annexure B, none of them are qualified under 143 to be even eligible under the pension rules. The mother, married daughter, and presently even Deepshika Bora is a married daughter. The respondent admittedly is the wife, though not the direct biological mother of the two Glipika Bora and Deepshika, but the second wife of this, and I think his name was there in the no, name was in the middle thing. And here I will take your lordship now to some judgments of this. Why I am trying it is that pensions to be disbursed is to be governed exclusively by the rules, your lordship. And no court can deviate. The first judgment, or latest judgment, 2024, 9 SCC, page 331, your lordship. In this case, I will take your lordship directly to para 46, your lordship. At the bottom of page, it would be 23, your lordship. At the bottom, your lordship will be para 46, if your lordship has got it.
Yes.
The common thread on the above referred judgments of this court is that the pension is a right and not a bounty. It is a constitutional right for which an employee is entitled on his superannuation. However, pension can be claimed only when it is permissible under the relevant rules or scheme. This is the ratio I want to emphasize upon. Because until and unless a pension is allowed or to be paid under the relevant rules or scheme, no person, even an employee himself, cannot claim. If an employee is covered under the Provident Fund scheme and not holding a pensionary pool, he cannot claim pension, nor the Rate Court can issue mandamus directing the employer to provide pension to an employee who is not covered under these rules. So the Apex Court has clearly stated that even the Rate Court under 226 is not entitled to direct deviation from the pensionary scheme. If the scheme is there, it has to be followed in toto. It cannot be any deviation, your lordship. And the same thing was reiterated long back in 1971, your lordship, which I had given another judgment. Now, I have highlighted some portions in those judgments, in that particular judgment. If your lordship kindly come to page 342, that is at page para 26.
Yes,
I had highlighted some portions in the, your lordship has got it.
yes, yes.
We have only referred to some of the important rules, if your lordship has seen the highlighted portion here. Rules to show that the payment of pension does not depend upon the discretion of the state, but on the other hand, payment of pension is governed by the rules, and a government servant coming within the rule is entitled to claim pension. This has been reiterated again in those various things that the rules are sacrosanct and cannot be deviated from by any court of law. Now, taking that into aspect, your lordship, another point which I think my learned colleagues would come forward and say is that family pension, first class legal hair, etc.
No, but I'm not speaking part family pension.
So if that is so, there was a point.
Since Wildna, I said the central law that family pension. As to that part, the order passed by the learned trial court needs to be interpreted. That needs to be interpreted. No, there's wrong.
And
I'm not. I'm not contending as regard to the family pension. It's a settled law. Family pension cannot be interpreted. No succession can be granted.
So if that is so, your lordship, that there was a statement in the judgment, interim judgment, whereby the Indian Hindu Succession Act was made a reference to. For that purpose, I just want to place a particular judgment, which clearly says that a Hindu Succession Act cannot be made applicable in a succession certificate. And this is a 2016 SCC 2298. Here your lordship will find, I will take your lordship.
Yes.
I'll just for a few. Here, your lordship, the Apex Court, while interpreting the Section 8 of the Hindu Succession Act, had defined the family and as well as the family's pension scheme, whether vis-a-vis would be governed by this particular scheme as the first class legal heir, etc., which, while interpreting that, has clearly come to a finding that the family pension cannot be governed by the Hindu Succession Act. And for that purpose, it has to be read, Your Lordship. If I may read out, because it is a continuation from this some citations. Now, para 14, Your Lordship. Let us look at the provision of the scheme in pursuance to which pension is to be paid in respect of service rendered by this. Defined the term which reads as family. Now, this is the same scheme, almost parameteria with our pensions thing. Number 4, family for the purpose of this scheme includes the following relative of the wife in case of male, husband in case of female, minor sons, unmarried daughter, widowed, legally divorced. These are 2 are not there, but in our case, only 3 till D it is there. Now, thereafter, in para 15, the Apex Court says, so far as the respondent mother is concerned, she has not been included in the definition of the term family for the reason as per the provisions of subclause A such and such. Here, even though that particular scheme had permitted the mother to be included, our Assam pension scheme does not include the mother. So here your lordship will find mother and unmarried, married daughters are totally excluded. So the Apex Court, while interpreting that, had said that the mother cannot be brought into the ambit of a family in spite of the fact that in para 16 it is stated so far as the provision of Hindu Succession Act are concerned, it is true that the properties of a Hindu who dies interstate would first go to all the persons enumerated in class 1 of schedule as per the provision of section 8 of the said act. And therefore, as for the properties of late concerned, it would be divided among this which fall. But position in this case with regard to pension is different. So the apex court has clearly established family pension and other things have two different, though Hindu Succession Act would be governed with regard to the other properties, but pension cannot be brought into the ambit of a family by bringing in the Hindu Succession Act into picture. Para 13, 14, and 15, 16 are the, if it is read chronologically, we clearly establish this fact, Your Lordship. Now, on this ground, I have challenged this particular judgment because by this judgment, not only an application under 372 filed by the mother and two married daughters had been taken into consideration, but has also gone ahead and given succession to all the parties concerned, Your Lordship. If Your Lordship will see, another point which I like to draw Your Lordship's attention is under the Succession Act, only one succession can be granted. As Your Lordship, again, in the family pension, it is there. So in this case, my whole argument would be the application under 372 was not maintainable in view of a specific rulings of our Honorable High Court, because this Honorable Court has clearly held that debt and security does not fall, pension does not fall within the definition of debt and security. Secondly, even assuming those applications can be said to be sustainable, then also the definition of family under section 1, rule 143 of the family the pension code clearly debars the petitioners in the application filed under 372 before the district judge was not maintainable because they were not within the ambit of those family. And as I had pointed out in the last judgment of the apex court in the Nitu versus Sheila Rani, the mother and the other things, other persons who are not inclusive in that particular definition of the particular scheme cannot be stake their claim over the family pension, though they have ample right to the other debts and securities of the deceased. So here is a case, Your Lordship, whereby this trial court had transgressed into a jurisdiction which this court did not have, Your Lordship, and have, even assuming it had exceeded the jurisdiction by entering into the realms of a provision where it cannot go into, because it has given pensionary benefits to persons who are not covered under the scheme of the state of Assam. And another thing I'd like to draw Your Lordship's attention in the pension scheme, they may say that there is hardship, etc. There is a decision, provision in this particular code, Your Lordship. I'll take Your Lordship to (233), Your Lordship. Your Lordship. (233), 234, and 235. Now, why I'm trying to place this on record, Your Lordship. If there is any doubt as to the applicability to the scheme to a particular set of people, then it is only the governor on an application made who can transgress and go beyond that, Your Lordship. I'll just read out just for the thing, Your Lordship.
No, not necessary.
So that is the only thing I would like to say. Nothing more to add to this.
Yeah, please, Your Lordship.
So far as my submission is concerned in this regard, your lordship.
Mr. Borthakur,
Lordship.
let us keep the matter as further.
Lordship.
We have another matter.
Lordship.
Then
Then your lordship may fix it immediately after 11th, your lordship.
11th of
11th of August. your lordship.
heard Mr. Biswas, learned counsel for the petitioner, and Mr. Borthakur for respondent. Heard in part, lays the matter of it.
19th, your
19th.
21st.
Obliged, Your Honor.
Take note.
Item 20.
May I be allowed?
Matter will be passable for detail.
No, no, lordship. From 5 days, lordship, this matter could not be heard due to time constraint, lordship. Even his senior is also here, lordship. Stay is there in this matter. Execution has been stayed since 5 months. And execution cannot be stayed more than 6 months, lordship. On previous occasion also, we fixed the date.
Execution cannot be.
On previous occasion also, we request for fix this particular date, lordship. Because there is an urgency, lordship. Stay proceeding has already been stayed since.
But today it cannot be completed.
Yes,
And we have some
also-
other matter also.
In that case, lordship may fix the date and item as first item, lordship, because every time this matter could not be heard due to time constraint, lordship.
This is of 2024 matter.
Yes, lordship. Since
Matters
5
of
occasions,
19
lordship, matter is fixed for hearing.
12, 13, 14.
Since 5 days, lordship, matter is fixed for hearing,
As
but could
agreed
not be heard.
by learned advocates of both sides. This is a list the matter on of it.
26th August.
Can it be before, prior to that, lordship, because
So many cases, only one bench. so
can
many-
it, lordship may kindly fix the matter as first item, because every time matter could not be heard due to time constraint.
On 26th August
26 August, okay. At 2 o'clock.
at 2 p.m.
Obliged, lordship.
On production list.
My lord, it is a very minor matter. The lordship has passed the improved order that lordship may kindly see page 27. Now, there is no dispute on that order, but thing lordship may kindly see page 57, my lord. This is the scheduled land of the respondent. Kindly see page 57. My lord, here one Amalindu Burwa, he was the from the Raj family, Raja's family of Obhayapuri. Now, Amalindu Burwa had 49 bighas of land. That lordship may kindly see page 56. Schedule A.
Mr. Pramod,
My lord.
we have not admitted this RSA.
Thing is this, my lord, if they file execution case, then execution cannot be made because they are, kindly see their page 57 for a moment, kindly see. 57. 57, schedule C, suit land. Suit land, land measuring 1 bigha.
Who are the review petitioner here?
Here the 3 persons, my lord.
Who are they?
Their names, lordship may kindly see. Page page 2. Gojen Das, Himanshu Kumar Das, and on the death of Himanshu Kumar Patgiri, his legal heirs. Now, lordship kindly see, very simple matter. I will satisfy your lordship. Now, lordship would say The respondent has said that my land is 1 biga, dag number 48, under Khotian number 52, New Kachapatta number 2. So these are the common land of all the parties, because Amarendu Chaudhary has 49 bigas of land, and he sold part by part to different persons. Now, here Lordship can say the boundary of his suit land, North Deepak Nath Dev, page 57 can see, page 57. His suit land is 1 biga and his north is Deepak Nath Dev, south Srimati Joymati Rai, east road, and west Amalendu Barua. Amalendu Barua is common because he has so many lands. Now, Lordship kindly see, respondents in TS number 72 has filed the case, that is page 79. Page 79. Here, it is ordered as the suit is civil in nature, hence the suit is maintainable, order plaintiff suit is dismissed. So, trial court dismissed the suit of the respondent. Now, first appeal was filed. Then in first appeal manner, first appeal, your Lordship, this first appellate court set aside the order of the learned Munshif. And thereafter, the present review petitioners filed the RSA. That RSA, Lordship may kindly see, page 27 is the RSA. Here, in this land matter, the total land, how their boundary is given. First, Lordship has seen already the boundary of C scheduled land. C scheduled land, page 57. Now, Gojan Das's land, page 14, kindly say. Page 14. Gojan Das's land, page 14, his 14 top. His north is Gajendra Kumar Das. South.
Mr. Mahmood, you tell me the present review petitioners are the appellant in the second appeal.
Yes.
Yes.
Now, Lordship, if they execute the decree, they will have to take our land, because in our land's boundary, he has no land at all. Can you see for a moment, page 14? Page 14, here, North Gajendra Kumar Das.
No. This appeal was not admitted.
Yeah. Appeal was not admitted, but at the time of motion stage, it was dismissed.
Yes.
So, now question is this, Lordship, there are a lot of judgments that if the judgments are carried out in a manner which ultimately would frustrate the cause of justice, because our land is totally different land. When 49 bigas, 14 lesses of land, our land is petition number Gojan Das versus 1 kara 10 lesser land, page 14. Now his north, Gajendra Kumar Das, page 14, south, Tarapal, east road, west Kalpana Das. Here Lordship would say, no boundary is tally.
No. We have not admitted the appeal. And whatever the trial court and the first appellate court has observed, that remains same. No, the first appellate court has observed remain same. We have not interfered with the first appellate court order.
Not interfered. But thing is this, if they want to execute the decree, there are a large number of judgments that even the executive court cannot execute the case.
That is the business of the execution court.
Yes.
Executing court.
But here,
If
lordship,
any problem arises, you file a petition there, executing court.
my lord, I'm giving one instance, my lord. There was a judgment against a deceased person who died. That was a nullity. Then our High Court directed the petitioner Jahana Begum that you file a petition that the schedule of the land are totally different. Number one. Second thing, the person has already died, but their legal heirs not brought on record. Here, lordship is correct that the first appellate court has allowed the appeal,
Hmm.
but the first trial court dismissed the appeal.
Hmm.
Now, automatically, first appellate court's order is upheld by your lordship.
Hmm.
Now, if they execute the decree, their boundaries are totally different from our boundaries.
No, that is the business of the executing court. Executing court will look after it.
Then on that,
Whether that decree is executable or not, that is to be looked after by the executing court.
yes, madam. Then lordship may kindly dispose of the matter on the ground that the decree holder must execute the decree as per Schedule C of his land. Beyond that, he cannot go.
No, that kind of observation cannot be made in the review petition. In review petition, we have to see whether any error.
Our
happened.
land, there are building, there are so many battle nurse. What will be our condition?
No,
All these are,
you file an application there under section 47
yes,
and
47.
rule 2197 to 101.
Yes, that is there are 150.
Order 21
52
rule.
of the CPC.
Yes.
Then lordship may kindly give us that liberty. Give us that liberty because High Court's order, lower court does not dare to touch.
No,
So
the question of touching this order does not arise because we
Arise
have not
because-
admitted the appeal.
But for a moment, my lord, if they execute the decree, that is totally a different plot of land. That is our land.
Okay. Heard Mr.
I'm really
Mahmood,
fine.
learned counsel for the petitioner. This review petition is referred against the for review of the order
Yes, sir.
dated 27/6/2025 passed by this court in RSN number 90 of 2025. After hearing Mr. Mahmood, learned counsel for the petitioner, this court is inclined to dispose of this petition, granting Mr. Mahmood, granting the petitioner liberty to raise the issues before the executing court in the event of an execution case being filed by the respondent herein.
Yes. And the learned court will consider the same.
No. In view of order passed in review petition,